Tuesday, February 10th, 2021. It is approximately 8:52. This is a test for the YouTube video.
Morning, Chief.
Good morning, Commissioner Byrd. Sorry, I was on the phone. Couldn't immediately respond to you, but good morning once again.
Yep. Good morning. I knew you were busy. Not a problem. Thank you.
I do got to jump back on a phone call real quick. I'll be right back.
Good morning, Renee Kepler.
Good morning. How are you?
I'm good. How you been?
I'm doing good. Hanging in there. Busy, busy.
Good. That's why you get the big bucks. Keep you busy.
Yeah, I guess so. Not really, but hey,
uh,
I
just
guess
wanted to say hello. We haven't talked in a long time.
I know. Well, good to hear from you. Hope to see everybody soon.
Yeah, absolutely. I agree.
You take care and hang in there.
All right. You too. Bye.
Bye-bye.
Good morning.
Good morning,
Good
everybody.
morning. Good morning. Good morning.
How are you doing, Commissioner Byrd?
I'm doing great. I'm out here, away from all you guys.
Well, we feel the same way. But I
Well,
have
I'm
heard,
glad that way you don't come out here, see?
yeah. But I have heard that Commissioner Hall asked how you are, but she apparently doesn't care about me.
Oh, I do apologize, Mr. Chair.
Yeah,
Oh.
yeah.
Well, you weren't in the doctor's office last time we talked, and he was, and we didn't talk, because that's where he was.
That's true.
And he's still here with us, so it's all good.
That I'm glad of. Good morning, Joe.
Good morning, commissioners. How are you?
Very
Good
well,
morning.
thank you. And you?
Got the sport coat on with a button-down collared shirt.
Okay.
I may have to get my suspenders out. I have a wide array of different colored suspenders from the 90s, just so maybe the chair won't feel so all alone in his fashion statement.
All right.
Uh-oh. Uh-oh.
Uh-oh. Here comes.
Here it comes, folks.
All right.
Boom.
I refuse to be outdressed.
We're all tailored.
Yeah, but you still are.
Okay. Bird, can we cut, Jason, can we cut Bird out of this meeting? Is there a way to do that?
Aw, no.
Yes, Mr. Chairman, I would need a motion.
I moved it.
Bring some life to it.
Commissioner Vicente Aguilar, I'm not showing many folks on my screen here. What's going on?
Well, Mr. Chairman, I have.
I'm here, Mr. Chair.
Yes,
Oh.
I was also going to recognize Commissioner Vicente Aguilar is here as well. So 19 participants.
Mr. Chair,
Yes.
before we start the meeting, I have a doctor's appointment at 10 a.m., which I could not cancel. So I'm going to join the meeting and then I'm going to leave and then I will rejoin later. So just to let you know.
Thanks for the heads up. Okay, I've got 9:30, so why don't we get started? Pledge of Allegiance, I want to do, I'm going to do Cynthia. I see you on the screen. Go for it.
I pledge allegiance to the flag of the United States of America and to the republic
for
which it stands,
one
one nation,
nation,
under God, indivisible, with liberty
and
and justice
for all.
Well,
I salute the flag of the state of
New
New Mexico,
Mexico,
the Zia symbol
symbol
of
of
perfect friendship
among
united cultures.
cultures.
Okay.
And by the way, I'm providing the state flag, as you can see behind me.
I appreciate that. I noticed.
He's better dressed. He's more patriotic. They just
Well,
have
it's
to
just, it's
compete.
almost heroic.
So consideration and approval of the agenda.
So moved.
Mr.
Oh, go
Mr.
ahead.
Chair,
Commissioner Byrd.
I wanted to move item 20-00239-UT, matter of T-Mobile, into the consent.
I'll second that.
Okay, Judith or Mike, who's there? Whichever, take the vote.
Also, one other question here before we, in light of the information that Commissioner Vicente Aguilar provided, is there any subject matter that she would not want to miss?
Good point.
and maybe should be moved up.
Boy, I think the next thing we can do is if we approve the consent, get to items 5 and 6 quickly before she leaves. And that might be the
Yeah,
best thing
I
we
agree.
can do.
Okay, I'm fine with that. I just being considerate or trying to be.
Yeah.
Mr.
thank
Chair?
you. Yes, Commissioner Vicente Aguilar.
Thank you for your consideration. It involves my vaccine shot, so that's the reason why they didn't tell me the exact time, but they said they will call me as soon as they get me out of the car.
Okay.
So, what we might do, well, first let's vote on this consent item and then I'll make a suggestion so that we can get to 5 and 6 quickly for Commissioner Vicente Aguilar. So
On the amendment.
Can we take the vote, Mike or Judith?
Yeah, Commissioner, can you hear me?
Yes.
Okay. This is to approve the agenda.
This is to approve the agenda. Let's see if we can roll it together. Approve the agenda while moving with the amendment of moving item 4 into consent.
Okay. Commissioner Fishman,
Aye.
Commissioner Hall,
Aye.
Commissioner Maestas,
Aye.
Commissioner Byrd,
Aye.
Commissioner Vicente Aguilar.
Aye.
The motion to approve the agenda as amended passes 5-0.
Okay, and now I just had to break this out separately. Is we can, if this works better for Commissioner Vicente Aguilar, perhaps make one final amendment to the agenda to move items 5 and 6 to the next item on the agenda, which would move it just above item 3, so we can get that discussion done before she has to leave.
I'll second that.
Okay. So Judith, is Mike available to walk us through that?
I am.
Okay, great.
Couldn't
So
tell
let's
if
take that. I'm sorry, go ahead, Judith.
I couldn't tell if Mike was around, but go
okay.
ahead, Mike.
So let's take that vote on moving those 2 items to next on the agenda and take the roll.
Commissioner Byrd,
Aye.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall.
Aye.
Commissioners, the agenda is changed. The agenda is approved by a vote of 5-1. I mean 5-0. Excuse me.
Okay, so Michael, let's go to item 5 on the agenda and take it away.
So, Commissioners, I actually was going to recommend that we address both cases at the same time.
Okay.
If that's permissible.
Okay with me.
No objections, it seems.
Yeah, they roll together.
That's a good way to
So,
put it.
Commissioners, these 2 cases, the reason I'm asking to address these 2 together is that they concern the same issue, the subject issue, which is PNM's possible recovery of its undepreciated investment in the power plant as energy transition costs under the Energy Transition Act in its abandonment case that has been filed now, which is case 2117. These cases both predate the filing of that case. However, because the case has been filed, that really these motions have to be addressed, or motion and complaint have to be addressed in the that pending case. These two cases both asked the commission to conduct hearings on the prudence of PNM's investments in the Four Corners power plant that were deferred by the commission's final order, revised final order, excuse me, in case 16276. Those prudence determinations would be conducted inside of the context of a rate case, as was contemplated by the revised final order in this case. And it appears that the purpose of seeking this ruling from the commission on prudence at this time would be basically as a part of an effort to deny PNM its continued recovery of Four Corner investments in under the Energy Transition Act.
Michael, you're coming in a little bit faint. Is there something you can do over there?
Let's see.
I know Commissioner Hall in particular would appreciate a little more volume.
Yeah, my computer's
Thank you. I appreciate that.
overheating, so I'm hoping that's not messing with my audio. Let's see, what was I? Oh, okay. So Sierra Club is seeking to get this hearing by reopening PNM's last rate case. This is the 16276 case, and New Energy Economy is seeking to get a ruling on the prudence issue by filing a complaint which requests an investigation into PNM's inclusion of the Four Corner power plant's costs in rates. The complaint doesn't really specify what the effect of the investigation would be. The New Mexico Attorney General, New Mexico Area, CCAE, the City of Albuquerque, Bernalillo County, the PRC staff, and Western Resources advocates variously support either reopening 16276 or addressing the prudence of PNM's Four Corners power plant decision-making as part of the abandonment filing in case 2117. None of those parties filed their own responses, however. The Bernalillo County Water Utility Authority and New Energy Economy did file separate responses in support of the Sierra Club's motion. So I'm going to address the first file I guess I'm going to address the first matter, which is the complaint. New Energy Economy's complaint seeks an investigation and hearing on the reasonableness and lawfulness of PNM's continued reliance on what they term climate-altering uneconomic coal at the Four Corners power plant. New Energy Economy describes this issue specifically as whether current rates, which include the costs of Four Corners power plant, are unfair, unreasonable, or unjust, and whether PNM's reliance on Four Corners power plant coal to serve PNM's captive customers is in the public interest. New Energy Economy asserts that the Commission's revised final order in case 16276 recognized that PNM's continued participation in Four Corners power plant was imprudent. It argues that by deferring a ruling on the prudence issue to PNM's next rate proceeding, the Commission established the basis for New Energy Economy's demand in its complaint that the Commission address PNM's continued reliance on Four Corners in an investigation now, rather than in the rate case proceeding identified in the revised final order. New Energy Economy asserts that this is proper because PNM has not filed the rate case that was contemplated. It should be noted that NEE, New Energy Economy, opposed the terms of the revised stipulation that was adopted in 16276, arguing that if PNM's investments were imprudent, the law requires that there be no cost recovery from taxpayers. New Energy Economy also noted that it did appeal the Commission's decision to the Supreme Court on appeal, but argues that it dismissed that appeal based on its understanding that the inclusion of Four Corner power plant investments in rates under the revised final order would only take effect for a limited duration of time. It notes that the parties who answered New Energy Economy's brief in chief on appeal acknowledged that the commission order would suffice to protect ratepayers for the limited time that the revised stipulation would remain in effect before the need for any additional disallowances can be addressed. New Energy Economy states that it withdrew its appeal on behalf of ratepayers, banking, as it states, banking on the vested rights and remedies to challenge the foreign.
Mr. Chair, it's hard to understand Mike. He's breaking up quite a bit. I wonder if he could just maybe speak a little slower or something so we could discern words better, because I'm getting a lot of breaking up there. I don't know about you.
Yeah, the signal's still pretty weak, Michael, so.
Maybe, Michael, if you could just start with the Supreme Court, what you were discussing about the Supreme Court with respect to New Energy Economy's appeal. Could you say that part again? Because your words were really lost to me. Did you hear me, Mike?
Yes.
Much better.
Is it much better now?
Yeah.
Yeah.
Okay. Let's see, where was I? So PNM, let me see where I was. So NEE basically states that it had withdrawn its appeal based on the idea that the rate case, rather the rates that were in effect would only be in place for a limited period of time. PNM and So New Energy Economy's argument was that PNM was initially scheduled, as it states it, to file its next rate case in 2019, but because of the Energy Transition Act cases, postponed it to 2020. Then the coronavirus hit, and rather than file a general rate case, PNM chose to file a decoupling petition in case 20-121. New Energy Economy rather complains that PNM's imprudently procured Four Corners coal has been in rates for 4 years. If this complaint is not investigated in a timely fashion, Four Corners will continue to be included in rates until at least July 2022 for a total of 6 years. 4 years, let alone 6 years, can hardly meet the definition of limited duration. Putting an investigation off because PNM has chosen not to file a general rate case strips ratepayers of the right to have the PRC fulfill its prior obligation to consider the prudence of PNM's investment in Four Corners Power Plant and to determine the appropriate associated disallowance, including the possibility of full disallowance. So that is basically the basis for New Energy Economy's complaint. The Sierra Club's motion
Still there, Mike?
Sorry?
I was just checking to be sure you were still
Sorry,
there.
I've got a lot of screens open here. So.
Okay.
The Sierra Club's motion argues that this case, that 16276 should be reopened to conduct the prudence review that was contemplated by the Commission's revised final order. It argues that this is consistent with the express intent of the Commission in its revised final order and the stipulating parties who agreed to the modified revised stipulation, which was to defer resolution of the prudence issue for a limited duration because the Commission and the parties contemplated that PNM would file a rate case for new rates to become effective in 2020. The Sierra Club argues that these issues are now ripe for decision in light of changed circumstances, specifically PNM's filing of an abandonment and financing application in advance of its next general rate case. Sierra Club's motion seeks to avoid PNM's undepreciated investments in Four Corners being treated as energy transition costs eligible for secured financing, stating that the requested prudence hearing should be done, quote, in order to avoid financing potentially imprudent costs and then having to consider the prudence of those costs in a subsequent general rate case. It argues that at the time the signatories in the 16276 case, the signatories to the stipulation, accepted the commission's revised final order and its modifications to the stipulation, no party to the revised stipulation could have anticipated that the Energy Transition Act would become law in 2019, or that PNM would seek to exercise the financing provisions of that law for the Four Corners power plant prior to PNM's next general rate case. New Energy Economy, in support of the Sierra Club's motion, argues that 16276 should be reopened and consolidated with New Energy Economy's complaint in the case 20-210 that I was referring to, because ratepayers have a vested interest pursuant to the Commission's final order in case 16276, and the relief requested is in the public interest. New Energy Economy argues that the intent of the revised final order was to defer resolution of the Four Corners prudence issue and the associated disallowances for a limited duration. It acknowledges that its request to reopen the revised final order seeks to counter PNM's request for full recovery of its undepreciated investment in Four Corners in its application for abandonment of Four Corners in case 2117 in accordance with the ETA. New Energy Economy acknowledges that this would effectively eliminate the Commission's ability to consider and impose penalties for PNM's imprudence as was contemplated in the 16276 case. It argues that its complaint in case 20-210 should be consolidated with the reopened case 16276 because cases involve similar questions of law and fact and address ratepayers' vested rights to determine the imprudence and associated cost disallowances of Four Corners before the PRC addresses securitization of Four Corners power plant costs. The Albuquerque-Bernalillo County Water Utility Authority also filed a response, and it argues that in agreeing to the Commission's revisions to the stipulation, all parties to the revised certification relied on the Commission's determination that the record would be preserved and the remedy for imprudence and recoverability of the Four Corners expenditures would be addressed in the next rate case. However, its proposed remedy is slightly different, and it proposes that rather than file that rate case, it argues, sorry, I have to pull my screen down further. It argues that the Commission should, quote, simply reopen the matter for the Commission to adopt the hearing examiner's findings of fact and conclusions of law and consider the limited scope of a remedy for PNM's imprudent actions. PNM responds to these arguments stating that the motion to reopen is contrary to the Commission's Rule 12237E, which requires that a motion to reopen be filed, quote, before the issuance of a Commission order or after the issuance of a recommended decision for the taking of additional evidence, and that this motion should be summarily denied because it was filed almost 3 years after the issuance of the Commission's final order approving new rates and closing the docket in 16276. It further asserts that the hearing sought by Sierra Club's motion and by the New Energy Economy complaint would constitute improper, piecemeal, and retroactive rate making. PNM also argues that the request for an order requiring the issue of Four Corners prudence be litigated as part of the Four Corner abandonment proceeding in case 2117 should be denied because PNM's recovery of its undepreciated investments in Four Corners through the securitized financing provisions of the Energy Transition Act must proceed within the legal framework of the Energy Transition Act. It does acknowledge that these parties, that Sierra Club and the other interested parties, have the ability to intervene in case 2117 to address the recovery of Four Corner investments pursuant to the Energy Transition Act. So the proposition that we really have in front of us is an argument in both instances that the commission's order in 16276 should be reopened to provide for relief that the parties are asserting was not contemplated at the time that that order was issued. This is a problematic request because, and what my proposed order would find is because really nothing in the commission's order in 16276 is identified as having changed as a result of the changed conditions that are being identified in these motions and in the complaint. The two issues, the two matters that are alleged to have changed are the early retirement of the Four Corners power plant earlier than any of the parties anticipated and prior to the next rate proceeding that was contemplated in 16276. The other issue is the passage of the Energy Transition Act itself. The early retirement of Four Corners would have involved, obviously, an assessment of what costs could continue to be recovered by ratepayers, and it would have addressed the issues of stranded costs in the normal manner that the commission has always addressed abandonments of plant. And I think it's proper for us to take notice of the fact that most of the parties in these proceedings and in some of the provisions in the 1676 case were intended to address the possible early retirement of that plant earlier than its scheduled retirement date based on its useful life. The real matter that's changed is the Energy Transition Act provisions, which would basically govern the commission's consideration of those stranded costs. And the parties' positions in this case, rather in this motion and in the complaint, openly acknowledge that that's the issue that they are responding to. I don't believe, and the proposed order finds that that's a proper basis on which for the commission rather, to reopen a proceeding and engage in essentially what most of the parties agree would be piecemeal rate making, or some sort of determination, because it's kind of unclear from these, from the motion and from the complaint exactly what the contemplated action by the commission would be, other than a decision on prudence in isolation from a rate case. And that would certainly be different than what the commission had proposed in its order in 16276, which was to address the prudence issue in the context of a rate case. So this would be a significant change from what the commission had contemplated actually in the 16276. And it appears to be an issue that would essentially be designed solely for the purpose of trying to avoid the application of the Energy Transition Act. What the proposed order would find is that the motion to reopen the 16276 case should be denied because the signatories, the benefits that the signatories had anticipated have not been altered by the two matters that they identify as being unanticipated. It does provide that the parties, while the commission rather would not reopen the 16276 case, the parties would still have the ability to raise issues in the 2117 case, and that related to whether the Energy Transition Act provides an opportunity for consideration of the prudence of undepreciated investments requested to be included in a financing order as energy transition costs, or what the effect of the Commission's final order in the 16276 may have had in terms of imposing black box rates on determining those energy transition costs. However, those issues should be raised in the 2117 case, consistent with the due process requirements that all the parties to that case have full notice and opportunity to be heard on those issues, rather than trying to issue a ruling that affects the 2117 case in a separate docket, in this instance, the 16276 case or the 21210 case. So consistent with that, the proposed order for the 2210 case finds that the complaint does not identify that that PNM's actions that did anything to violate any rates or other rules or orders of the Commission. The provisions of the 16276 order have been in place since the order was passed, and nothing about the change in the law has altered the terms of the 16276 final order. It is really only addressing the the terms under which the Four Corners power plant would be subject. So I stand for questions.
Commissioners?
Mr. Chair?
Commissioner Hall.
Oh, I seem to mute my, okay. Well, I agree with primarily what Mike has advised, but I do feel that in the 2117 case, well, what Mike has advised about the 16276 case, but with respect to the 2117 case, I think it's important to recognize that that case isn't just about abandonment, but it's about securitization. And it's, I think, paramount that we provide every opportunities to identify what the actual assets to be securitized are. And I don't think we could ignore the fact that in the 16276 case, prior to the final order, there was a previous final order that found imprudence with respect to the selective catalytic reduction technology for worth $90 million and another $58 million having to do with assorted other improvements that were related to environmental concerns and other improvements. And so that was a determination that was made by the hearing examiners at that time. And I don't think we can neglect that. And that was adopted in a final decision by the Commission, which then the week thereafter reversed, the Commission reversed at the urging of the parties because they, well, their reasons are somewhat irrelevant here, but I think it had to do with their anticipated other workloads and the desire to avoid more litigation at the time. I think that was the reason, but I'm not positive on that. I get that from one motion I read, but in any case, the parties wanted to postpone it until, as Mike said, the next rate case, which is our typical method for cleaning up other issues that need to be litigated in a way of pursuing judicial efficiency, among other things. So I think it's important that those issues are definitely aired in the 2117 case, because that's the appropriate place. And I don't think this would run afoul of the Energy Transition Act at all, because this is a predetermined fact. And it's clear that all the parties did expect to be able to reprise that decision at a later time. So I think we're only doing our duty to allow that information to be brought to the fore and heard in the abandonment and securitization case. So that's my feeling of it. I would move the order unless there's further discussion. I'm sure there will be further discussion, but in any case, that's all I have to say. Thank you.
Mr. Chair,
Yes, Commissioner Maestas.
for the purposes of discussion, I'll second Commissioner Hall's motion to approve the recommended order. But I do have some comments.
Okay. Is there any discussion from other commissioners?
Oh, Mr. Chair, this is Jeff.
Go ahead,
Mr.
Jeff.
Chair.
Well, I just have all
Teresa first,
comments as
and
well.
then Jeff.
Well, I have comments as well, so Commissioner Maestas can continue, and I just have comments afterwards. I'm not moving to change the order either.
Okay.
Thank you, Commissioner Byrd.
Commissioner Vicente Aguilar first, because she could be gone at any moment.
Right. That makes sense.
Mr. Chair, I'm done with my vaccine shot, but I'm in the waiting room, so I can freely talk now.
Oh, good.
I would join my colleagues with the motion and the second, but I do have comments after the vote.
So Judith, why don't we take a vote and we'll do some discussion afterwards? Or Mike?
No, I think the discussion should precede the vote, Mr. Chair, if that's okay.
Okay, that's fine. So Commissioner Maestas.
Thank you, Mr. Chair. The case 16276 obviously happened before my tenure on here, and so I looked at this, or at least that case, as someone looking from the outside, looking in, and it seems that the stipulation had many components to it. It had specific revenue reductions and one non-specific revenue reduction, but it just seems that that a black box rate, which was how we're phrasing the outcome of 16276, seems antithetical to what we do at the PRC. And so as an engineer, I look for the analysis to support, one of the major conclusions in that case. And one of them was, excuse me, the commission accepted the revised stipulation in lieu of a finding of imprudence and invoking any disallowances, specifically because the revised stipulation provided greater revenue reductions than what would have resulted from only the imprudence finding. And I think the conclusion was that the ratepayer interest was upheld because of those revenue reductions, were greater than any disallowances from imprudent costs. And so I didn't see any financial analysis that bears that out to make that conclusion that the final outcome represented rates that were fair, just, and reasonable. And so that's just my observation on 16276. But I'm heartened, with, our order that leaves open the opportunity for parties and interveners to revisit that, not only in the Four Corners case 2117, but also in the next rate case, whenever that will be. I suspect it will be after 2117. So I think in the future, I'm certainly going to ask those questions about the financial analysis. In fact, in my discussions over all these issues that are intertwined with NEE complaint, I believe we changed some of the requirements on our stipulations as a result of 16276. And before I relinquish the floor, I'd like Mike to explain what we now require on these stipulated agreements.
Mr. Chair, Commissioners, the principal change that the principal issue, well, there were a number of issues. 16276 was an extremely complicated back and forth on different issues. But the principal change that we adopted afterwards was to require that for the commission to consider stipulations, that the time that would be devoted to addressing whether a stipulation or certifying whether a stipulation was consistent with the public interest would not be counted toward the time, the statutory time that the commission has to address a filed rate case proceeding. And that was because in the 16th, and that's basically tolling. The reason for that was that in the 16276 case, the parties essentially asked the commission for the opportunity to address seek a stipulation. They negotiated one. It took a fair amount of time. The stipulation was opposed, which required a hearing. The hearing was conducted. A certification was drafted. A certification was presented to the commission. The commission addressed that. All that was eating into time for the statutory time to consider the rate application. And when we got to the very end of it, and there was a real option that the commission should just reject the stipulation, there was essentially no time left in that statutory time period. And my belief at that time, that I still hold firmly, is that any effort to argue that that time had continued to run during that period and that equitable tolling was not an option, I think would be false. But the commission at that time was concerned about that, and that operated as I think as a factor in their decision to enter the final order that they did. So now the commission does not entertain stipulations unless there is an agreement by the parties that there will be a tolling of the time it takes to address that stipulation.
Thanks, Mike. And I wanted Mike to mention that because he mentioned that to me in our discussions prior to the meeting. And I thought it was one of those lessons learned by the PRC in these stipulated agreements. So my final comments, Mr. Chair, I mean, part of that deal, that package deal in that revenue reduction was a partial disallowance of undepreciated assets in Four Corners. And I want to make sure that that's binding and carried over, and not just the basis for that portion of the revenue reduction. So certainly 16276 will have implications in 2117. And so I'm going to be looking at that. But again, I want to state that, and I still, I'm like that dog that just won't let go of that bone. I want to make sure that I see that cost equivalency of the revenue reduction in totality with what the ratepayers would have realized through disallowances of imprudent costs, especially in light of the fact that the stipulation required that PNM shall not implement any other non-fuel base rate changes with an effective date prior to January 1 of 2020. And so as an engineer and as a commissioner, I'm going to be looking with great interest in 2117 and the subsequent rate case. That's all I had, Mr. Chair. Thank you.
Thank you, Commissioner. Other commissioner comments? Commissioner Byrd, I believe you had some.
Mr. Chair.
Yes. Go ahead, Teresa. Commissioner Vicente Aguilar.
I'm sorry
Please
to
yield the
interrupt.
floor. Go ahead.
Okay, thank you. Thank you, Mr. Chair. I would like to compliment our general counsel. As you know, he has handled the previous cases, and this is thoroughly vetted. And we want to make sure that the costs, the revenues, all that is considered, analyzed for a fair, balanced, reasonable decision. I cannot say that I extend my gratitude to the talent and skilled, excellent employees that we have. Yesterday, I attended a hearing regarding electronic filing. Everyone, El Paso Electric, Zia Natural Gas, P&M, they are very grateful that we are continuing to do our work in a professional manner through the pandemic. And we are being people that we regulate, the companies that we regulate, they extend their gratitude for professional staff that we have, including our paralegal and the general counsel, Judy Amer. All the attorneys work as a team to protect New Mexicans on cost analysis. Our staff members, our legal division, we are so proud. I am so proud of our staff members. Even though we can function in a professional manner without an office. Right now, I am working off my work phone, and that's the way the state government would like for us to function. And that is not right. Our constituents call our office and our work office number. It's not functioning. We don't have an office. We don't have a landline to speak from. And that is a shame. But all in all, with very important cases like the abandonment of the Four Corners power plant and the other case that our general counsel covered, I am so grateful for the fantastic team that we have. We will continue to analyze. We will continue to review the rate cases, and I'm proud to be with my colleagues on this particular cases that we're going to be voting on shortly. Thank you very much, Mr. Chair.
Thank you, Commissioner Vicente Aguilar. Commissioner Byrd.
Thank you, Mr. Chair. So just general comments on this whole case. I don't know who's more surprised, but I generally find myself in principle agreeing with New Energy Economy and their arguments. And I don't know if it's Marielle or me who's more surprised about that, but I do agree. I think she's spot on. I think she's right. However, I have to agree with Mike, given the political environment we're in and the support that we've received. If I felt like we could be supported in a manner that would uphold law and the ratepayers, I would be pushing to go ahead and open this case up. But I don't think we would be. And so I think we have to take it up. We have to take this issue up in 2117, like Mike is proposing, and deal with it in the whole big picture, which sometimes confuses issue and makes it easier for the little nuances to get lost. And I'm not happy about that, but that's what we're dealing with in this current climate. And so I support this order that Mike has put up, and I think he's made the right arguments. And so I will be a positive vote for this order, but I just want to, I guess, tell New Energy Economy to keep up the fight. We won't always agree, but I appreciate her being out there and doing the work that she does. And that's it, Mr. Chair.
Thank you, Commissioner Byrd. And before the vote, I'll just make a comment. I too support this motion, but I really appreciate the Sierra Club and NEE for making these motions and bringing these issues to the fore. I think we have a record that can support a lot of different points of view from a legal standpoint. And the issues that have been raised here by the Sierra Club and by NEE deserve thorough vetting when we go through the abandonment case. And, I'm sure our hearing examiners are already preparing for that. Because there was a lot of thought and there is a lot of information on the record that, says, imprudence was a real issue. And as Commissioner Maestas points out, it appears from looking at the record, even though it was a black box settlement, there was a lot of discussion that settlement adjusted rates to try and account for the fact that these investments very well were imprudent. And that's all stuff that we have to look at very carefully and see how it applies in this case. So without prejudging, I just want to say, gee, there's a lot to look at there, and thank you to, even though these motions are being denied, we're going to pursue this in 217, and these issues will be thoroughly vetted, and I think folks got a sense that all the commissioners feel that way about this. So anyway, with that, let's take a vote.
Commissioner Vicente Aguilar.
Aye.
Commissioner Maestas.
Aye.
Commissioner Hall.
Aye.
Commissioner Fishman.
Aye.
And Commissioner Byrd.
Aye.
Commissioners, the proposed order passes by a vote of 5-0. Commissioners, actually, I'm sorry, I should have clarified which order. I had both cases up here. Perhaps we should clarify that this is on both orders that I had proposed. It just occurred to me. I'm sorry.
Yes.
Yes.
Correct. We said we were doing both when you initiated the discussion.
Okay. So for matters of the record, this was a vote on case the motion to reopen docket in case 16276 UT and the proposed complaint in case in case 20-00210 UT.
Correct.
And those proposed orders are adopted by a vote of 5-0.
Correct.
Correct.
Thank you, Mike. Thanks for taking us through that. And okay.
Mr. Chairman, this is
Consideration
Jason. Now that Commissioner Vicente Aguilar is back with us full time, I try to make sure I keep track of where we are on the agenda. So in my opinion, I think we're back to the consideration approval of prior meeting minutes as I have on the screen.
You are correct. And we've already approved the agenda. So on the minutes, we're gonna, any motion on that?
I'll make a
Mr. Chair,
motion
this
to
is
approve
Jeff.
the minutes.
Thank you. I've got Commissioner Vicente Aguilar's motion. Jeff, you wanted to speak? Go ahead.
Yeah, and I'll second the motion, and I want to tell Carl, I guess, thank you. The changes he made were basically insignificant to the meat of the minutes, but I appreciate him going back. I still swear that there was more discussion to that whole issue there. It seems to just fall on its face and we moved on, but I guess that's how we handled it. So thanks, Carl, for going back and checking that out. and we can move on. Thanks.
So are you seconding, Jeff?
I did, yes.
Okay. And real quickly, Mike, for clarification before we vote, we still do have the recording of the meeting, correct? So that we can refer back to that if we, need it for the record for any particular purpose.
Mr. Chairman, Commissioners, the minutes are the official required record of the prior meeting. We do maintain audio recordings of the meetings. I think obviously, I don't know that we actually have video of these Zoom meetings as part of that. Chief of Staff might be able to provide better clarification on that. I haven't been looked into that, but yes, we do retain it for a period of time, but the written minutes are the official record.
Okay, and if there's a question about the official record, even after we've approved, is there procedural opportunity to go back to the recording if we need to verify?
Mr. Chairman, Commissioners, I'm a little, I'm not sure how to answer that in terms of procedural opportunity. There really is no, procedure in place because, as I stated, under the Open Meetings Act, the Commission is required to prepare written minutes of its meetings, and so that's the official requirement that we meet by.
Okay, but there's nothing stopping us from, if there's a question about those minutes, from referring back to the recordings to clarify.
Mr. Chairman, Commissioners, to the extent you would like to subsequently revise the official minutes, you have the audio minutes, or rather, excuse me, the audio recording available to refer to. And there have been times in the past when parties in cases on appeals have asked court reporters to prepare transcripts from those recordings. And they have been, I don't believe it's ever been litigated because it's always been agreed to submit those into the record. But currently those are not part of the official record.
Okay, I understand, but we can still use them essentially if we need to, the recordings.
Yeah.
So
Mr. Chair.
is what I'm hearing you say, correct?
Mr. Chairman, I think you're asking a practical question versus my legal answer.
So give me a practical answer, Mr. Lawyer.
As long as the Chief of Staff maintains them on our website for you to access, yes, you have access to them.
Okay, thank you.
Mr. Chair.
Yes, Commissioner Maestas.
Just a little more discussion on minutes in general, since we're talking procedure.
Sure.
My experience, being on other governing bodies is whenever we would discuss or consider an action that could be subject to appeal or was contested, we would go to a verbatim, we would insist on a verbatim recordation of minutes. And I know that our minutes are somewhat summarized, and since they could potentially be the source of litigation and appeals and pleadings, does the PRC, as a matter of practice, determine at the outset of a discussion, let's go to verbatim minutes? And if not, just based on reviewing the minutes, it seems that we don't as a matter of practice. But I would maybe appeal to my colleagues that if we're entering maybe potentially litigious territory, that we go to a verbatim recordation of minutes. And I don't know how Mike feels about that, but I think it's better. It protects the commission. It presents a more thorough record. So anyway, that's just something I noticed in our minutes, and I just wanted to see if that could be a potential practice for us in lieu of having folks go to audio recordation.
So
Mr. Chair?
Commissioner Maestas, I think it's good to try and tie that down. I can see some potential just sort of pragmatic execution issues on that. But Mike, what I think we should probably do is you should take a few minutes and prepare. Let us know, what the obstacles might be to that, if any, and if we can do it, and how we can do it, and maybe you and Jason could just get together and let's put that on next meeting's agenda right now. That you prepare a few thoughts on that, because I think that again, as usual, Commissioner Maestas has very good procedural suggestions. So,
Mr. Chair?
yes, Commissioner Hall.
I just wanted to say this is the first time I've heard that we don't keep all the recordings indefinitely, because I think that our minutes absolutely do not capture everything that we say. I mean, it looked to me like they're a document that's intended to kind of summarize and truncate. And I think I totally agree with Commissioner Maestas that we need to have verbatim. And frankly, most of our meetings contain some item that could be appealable and for which we need a far better record than we keep. So I think in the interim, until we make any decision, we should absolutely be not destroying any other destroying or throwing away any other recordings, because they're our only verbatim record. And I've had occasion to want to look back myself, and I've been glad to always find a recording at least for which I could get a transcript. And I think getting the transcripts are more expensive, but at least if we preserve the recordings, we have that opportunity.
Mr. Chairman?
Yes.
So I can respond to this right now, which is that the preparation of a verbatim transcript of the commission's meetings is neither required by law nor advisable under the law, because this is not part of the evidentiary record on which the commission's decisions are reviewed on appeal. The commission's orders and the evidentiary record developed by the hearing examiners is the record that is reviewable on appeal. The other practical aspect of this is that Carl Boas is not a certified court reporter authorized to prepare an official transcript of the nature that you're discussing. He prepares at times more detailed transcripts than are required for minutes. And I err by saying transcripts, but he prepares more detailed minutes than are required by the Open Meeting Act, which in one of the previous meetings I pointed out only requires identifying the items that are on the agenda, the votes that were taken, and those kinds of basic facts. So I think it's actually not advisable to invite making the commission's deliberations and discussions that are not part of the commission's actual order that is issued, and which sets forth the basis, the reviewable basis for a commission's decision. I think it's inadvisable to try and take steps that would further the argument of people that things that are made during or statements that are made during deliberation carry weight beyond what should be accorded to them.
Mike, so I do think at a minimum, Commissioner Hall raises a very good point, which is at a minimum, I would like to feel like the recordings of the meetings are maintained for a long period of time. So when your comment that we do preserve them for a period of time, I think the commission would like to know, how long are you preserving those recordings?
And Mr.
And-
Chairman, I would respond that we would preserve those for the length of time that is required by the Records Act.
Yeah, do you know what that is?
Offhand, I do not. We actually had a discussion about that the other day, and I haven't had a chance to look at that.
So please get back to us with that, so we know that at a minimum. Any other discussion around this at this point? I guess we can check in with you and between now and the next meeting, and everyone can get their comfort level together on it. So certainly I understand your argument, but it may take a little more discussion offline. So we've got consideration and approval of prior meeting minutes. Let's take the vote.
Mr. Chair,
Yes, Commissioner Vicente Aguilar.
can you please state the date? Which minutes are we voting on right now?
So this is for the amended minutes of January 6th, 2021. The ones that were previously incomplete that Commissioner Byrd asked to revise.
Mr. Chairman, I did not get the motion and second.
So the motion, I can't even remember now. I think it was Hall, Commissioner Hall.
Commissioner Vicente Aguilar made the motion. I seconded.
Oh, okay. Thank you, Commissioner Byrd.
Mr. Chairman, with that, I will take the roll. Commissioner Hall.
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioner Maestas.
Aye.
Commissioner Byrd.
Aye.
Commissioner Fishman.
Aye.
Mr. Chairman, Commissioners, the amended minutes of January 6, 2021 open meeting are approved by a vote of 5-0.
I have to ask the forbearance of my fellow commissioners if I seem a little disjointed. I'm still totally shocked by Commissioner Byrd's admission that he agrees with Mariel Nanasi. So while I'm recovering from that, please bear with me.
Mr. Chair.
I had reservations about making that admission.
Well, Mr. Chair.
Yes, Commissioner Hall.
Under the circumstances, I'm not surprised.
Thank you. Introduction of special guests.
Mr. Chairman, this is Jason. If the commissioners don't have any, I would like to give the floor over to Utilities Division Director John Reynolds to recognize a new hire within the Engineering Bureau.
John, go ahead.
Morning, Mr. Chair and Commissioners. I'm pleased to let you know that the Utility Division has hired Eli LaSalle. Mr. LaSalle is joining the Engineering Bureau as of this past Monday. He is a 2019 graduate of the University of Arkansas with a degree in biological engineering. He has registered with he's certified by the state of New Mexico as an engineer intern. And we're very pleased about this addition. This is the first new hire we've had in a long time, certainly during the pandemic and even sometime before that. So I know we're very happy to add to the ranks of our engineers, and there's a lot of work ahead, as everybody knows. And so would like to welcome him to the Utility Division and to our agency. Thank you, Mr. Chair, Commissioners.
Thank you, and welcome aboard. Commissioner Hall?
Well, I was just going to say, it's glad news. I'm very glad we're hiring another person, and he sounds like he has a very interesting background, and I welcome him.
Mr. Chair.
Mr. Chair.
So I believe Commissioner Maestas got in first. Go ahead, Commissioner Maestas.
Thank you, Mr. Chair. I just wanted to, welcome Eli, welcome him aboard to the PRC team. And, being an engineer, it's good to see a an engineering graduate, joined the tech team as an EIT. Eli, welcome. It's great news.
Commissioner Byrd.
Well, I just want to say that, it seems like we're always hiring those dang attorneys, and it's great to have somebody with some common sense, an engineer, come on board. That's going to be a good addition to the PRC. And no matter what, good luck, Eli. I hope that you find a home here and serve the state of New Mexico well.
Well, Commissioner Byrd threw out some red meat there, but I just want to officially forbid all of the attorneys in the agency from storming the homes or the offices of any of the engineers in the agency. I too welcome more engineers, and I'm sure we will be partners going forward. And welcome aboard, Eli. Thank you. Next, we're on to public comment.
Mr. Chairman, this is Jason. We don't have anybody signed up for public comment today. Thank you.
Okay, thank you. We're on to the consent action items. Do I have a motion?
So
Move to
moved.
approve. Second.
I missed who did that.
Mr. Chair,
Yes,
just a quick comment before we go to the vote.
sure.
On 18-00374, we get half the story here, Miss Amir. I hope that there's some relevant information that's missing, but if there's not, based on what I read, I'm concerned about what our hearing examiner was thinking. And so I hope that this sets all that straight, and this just seemed off to me, but I agree with the order that you have put in there, and we'll move forward. Thank you.
Any other commissioner comments? Okay, let's take a vote.
Commissioner Maestas,
Aye.
You might want to read the items and the new item that we've included, Mike, before we vote.
thank you. Mr. Chairman, Commissioners, this is the vote on the consent action items, which are comprised of case 18-00374 TREN in the matter of the formal complaint of Crystal C. Winters against Superior Ambulance Service, Inc., DBA Superior Medical Transport, and We Care Transportation, potential order on request for stay and for mediation, and order regarding notice of hearing examiner. 21 quadruple 4 TRM in the matter of the application of Sierra Vista Hospital, DBA Sierra Vista Hospital Ambulance, for reissuance of certificate number 54212 to provide ambulance service, potential order regarding application for reissuance of certificate, and case 20-00185 UT in the matter of the application of New Mexico Gas Company for a variance from Rule 1710-640 for its October 2020 gas cost factor statement, and that's a potential regarding the variance. I will take the roll call. Commissioner Maestas.
Wait a minute.
I think we skipped item number 4 that was added to consent.
Oh, I'm sorry. Yes, I'm sorry.
Yes.
Item 4 that was added is case 20-00239 UT in the matter of T-Mobile West LLC's petition for relinquishment of its mobility fund. What? I'm not sure if that's a type. Mobility fund eligible telecommunications carrier designation pursuant to 47 USC section 214(4). And this is a potential order for staff response to the petition. And based on that, I think I named them all now. So I will take the roll. Commissioner Maestas.
Aye.
Commissioner Hall.
Aye.
Commissioner Byrd.
Aye.
Commissioner Fishman.
Aye.
Commissioner Vicente Aguilar.
Aye.
Mr. Chairman, Commissioners, the consent action items are approved by a vote of 5-0.
Okay, on to item 7, a discussion on process for selecting Transportation Division Director. Commissioner Maestas.
Yes, Mr. Chair. As you all know, we have a vacant transportation director position. It's an exempt position subject to advice and consent by the commission in terms of the selection, but we have a unique situation in this case in that our chief of staff wears 3 hats. He's the chief of staff, he's the pipeline safety bureau chief, he's also the acting transportation director. And so I've had a number of discussions with Jason, our chief of staff, and with Mike Smith with OGC. And we've been consulting with Mr. Borman and the legal division on really how to insulate Jason Montoya from any conflicts in the selection of the transportation director position. And so right now, the status of it is that applications have been accepted. It is considered open until filled. So what I propose to the commission, and again, this is to eliminate any conflicts of interest or any appearances of conflicts of interest, is to have a subset, a non-quorum subset of the commission, 2 commissioners, basically oversee the selection process for the transportation director in lieu of the chief of staff. I would like to be involved in this, and what this would entail is that the commission would concur with 2 commissioners to oversee the selection process, and that would entail the screening of applicants, the shortlisting of applicants, and the identification of shortlisted candidates for interviews. And those 2 commissioners, once they agree on a recommended candidate, would bring it to the full commission for final selection. And so that is my proposal. And I'm asking, well, first of all, regarding this process and this approach, are there any questions regarding this approach to filling this position? And the advantages is we would fill the position, we would relieve the burden, the additional burden on the chief of staff of wearing that 3rd hat. And it would be consistent with our protocol and operations to really ensure that we're transparent and that we're taking proactive, positive steps to eliminate any conflicts of interest and insulate employees from those conflicts.
Mr. Chair?
Commissioner comments?
Mr. Chair?
Commissioner Hall.
So I am interested to understand what's the nature of the conflict of interest or the possible appearance of a conflict of interest? What would be the conflict of interest?
Right.
And maybe Mike could address it if you want him to.
The transportation director would be Jason's boss, because he's still holding the Pipeline Safety Bureau hat. And the transportation director would be a direct report to the chief of staff. That's not the conflict. The conflict is Jason wearing the Pipeline Safety Bureau hat and being involved in the selection essentially of his boss.
Mr. Chair.
I see.
Commissioner Byrd.
Sorry, was Commissioner Hall going to ask another question there?
No, I understand what he's talking about.
Well, I would like to help Commissioner Maestas with this process, if that's all right.
Mr. Chair?
Commissioner Vicente Aguilar.
We need to be very careful, very cautious when it comes to hiring division directors. Normally, we ask for a closed session so that the commissioners can share their vision. what I would like to do is, in the future, let's go into a closed session because it's not right to examine and make judgment of our chief of staff in the public. We all know he's doing a wonderful job. So I'm a little bit cautious that we should not be putting this on the agenda for an open session. I think we should go into a closed session. But that's just my thought. But I'm happy with Commissioner Maestas and Commissioner Byrd to take the lead.
Mike, Commissioner Hall had asked for your explanation of the conflict. Commissioner Maestas gave a nice, concise picture of it, but I wanted to hear from you as well.
Mr. Chairman, Commissioners, I haven't been involved in all the discussions that came up with this proposal. There was a discussion regarding, the perceived conflict of interest in a employee, I guess, let's put it that way, somebody being involved in the selection process of their own boss. Obviously, the final, whatever the chief of staff's final decision is in terms of hiring a division director by statute is subject to the consent of the commission. So there is a process that over that. The different ideas that I had were based on the means that had been employed in the past at the commission, which included basically having a committee, I guess let's put it that way, of different division directors review the resumes and present to the commission a proposed list of finalists for them to review. So that was one of the options, but I think that's about all I can really say. I mean, in terms of, to the extent that the commission wanted to avoid that potential conflict of interest.
Yeah.
Mr. Chair, and let me just clarify that this has nothing to do with Jason's performance. It's just really meant to shield him from any conflicts of interest. And I also want to add, and I didn't mention this, is Renee Kepler, head of human resources, will assist if you agree with having myself and Commissioner Byrd kind of oversee the selection process. And there's nothing to preclude us from consulting with Jason, as he is wearing the chief of staff hat. That is his primary hat, after all. But I believe that doing this will protect him from any conflicts.
So I'll just make a couple of quick comments, and then I'm going to make a motion, which is philosophically, I always like to let managers make their own hires and create their own team. And so typically, I would say, oh, let's stay out of it and let Jason pick his person. But the issue that you're raising is very clear, and I get it, and we do need to address it. I think what you're suggesting makes sense, and it makes me feel better that you're saying, hey, we will consult with Jason. We're not going to just stick him with somebody where there might not really be a fit. So that's great. And it sounds like we have two commissioners who are very interested in following this up. So if you don't mind, I'd make a motion to assign Commissioner Maestas and Commissioner Byrd.
I'll second that.
to lead the selection process. I'll just finish this thought so we have a complete motion here. To lead the selection process in lieu of the chief of staff. So that's my motion. I believe we still have a second from Commissioner Hall, correct?
Yes, you do.
And any other discussion before we take a vote?
Mr. Chair.
Yes, Commissioner Byrd.
I just want to basically reiterate what you were saying. You know, this is chief of staff's job, but he is his own grandpa in this situation.
Yep.
And it is for his best interest to not be hiring his boss. It could cause all sorts of conflicts within the agency. But I also agree with Commissioner Vicente Aguilar. Jason's doing an outstanding job. I really wouldn't have any concerns with him hiring the division director. But it's that perceived problem that is an issue. And of course, I will always refer to Jason's opinion, but I think we need some neutral position. And being that he is the chief of staff, the only people higher in rank than him is us. And as Commissioner Maestas pointed out, we can't have, to avoid any problems with the quorum, we have 2 commissioners involved. But as we've learned, hopefully we've all learned, we will include the other 3 in every major decision, so that nobody feels like they're being left out or stepped on, and I think that's only right. So that's why I jumped on to help Commissioner Maestas with this. So thank you, Commissioner Maestas, for bringing this up, and we'll move forward and try to get it done in a timely fashion, because that's an important position that needs to be filled.
And Commissioner Byrd, I agree with everything you said. The only scary part was when you said that we're all senior to Jason, which may be the biggest mistake in this agency of all. So
Speak for yourself.
Right.
So at any rate, if
Exhibit A.
It's probably true.
Grandpa, so I don't know how much more senior you can get than a grandpa, so.
Okay. So we're ready for a vote, I believe. Mike, would you take the roll?
Commissioner Hall.
Aye.
Commissioner Maestas.
Aye.
Commissioner Byrd.
Aye.
Commissioner Fishman.
Aye.
And Commissioner Vicente Aguilar.
Aye.
Mr. Chairman, the commissioners, the designation of Commissioner Maestas and Commissioner Byrd is approved by a vote of 5-0.
And thank you, Commissioner Maestas and Commissioner Byrd, for taking on this task. We appreciate it. So discussion items, we had our, I guess on Friday, that seems so long ago already. We had our 2-year plan workshop, round 1, I guess. And folks have had a few days now to think about it and what we heard. And I think what I'd like to do is just open it up for discussion about commissioners' thoughts for next steps now that they've had a chance to sort of review what we covered last meeting and how they'd like to move forward.
Mr. Chair.
Commissioner Maestas.
One thing that I was concerned about at the outset of our discussion in kicking off the 2-year plan was that we have a scribe to capture kind of the essence of some of the recommendations. And I think initially Isaac had been doing that, but he had to work, I think, on the agenda for the next meeting last Friday. And so he handed that off to my assistant, Jonas. So Jonas has captured the results of that discussion. And I don't know if you want to have a recap on what we have discussed and perhaps identified as potential elements of a 2-year plan, or if you want to wait until we complete the entire discussion. So that's just maybe a procedure issue. The other thing too is I don't believe we're quite done with presentations from others besides commissioners. I think Arthur O'Donnell still has to present. So as we resume that, I'd like to hear from Arthur and his presentation. His was by far the best looking and the most detailed. But so two questions or two comments. I feel perhaps we should start this by going over what we discussed in the previous session. And Jonas has some bulleted notes. And then the other is when we resume, we should start with Arthur, because I think Arthur was the last person that had not presented in terms of non-commissioners.
Okay. Commissioner Hall, were you about to speak?
Well, Mr. Chair, I just don't seem to have Arthur's list. Was that shared with all the commissioners? Because I
had a
don't have.
presentation that was part of the packet, and it was basically the I don't know if it was a draft or the final product of the task force that he was a part of that
That's right.
generated the goals
Yeah.
for grid transformation, modernization,
Right.
excuse me.
Right. I just.
So that's what that entailed there.
Yeah, I recall that now. Yeah.
I happen to agree with Commissioner Mastis that
Yeah,
for the next round, we should hear from Arthur, and that might be the right way to lead off before we hear from the commissioners on what their priorities are. My thought had been to basically schedule a follow-up meeting, not to discuss all the issues today from the last meeting, but to do that review as part of the follow-up meeting, because I want to link them to whatever the commissioners' goals are. We talked a lot about process, it seemed to me, and we got some really good input on process from staff and everyone that we could improve. But to me, what makes it all work is linking that process to the bigger goals, the bigger policy goals. And that's kind of what I was thinking we'd try to achieve in the next meeting. So I'll just open it up for more commissioner comments and see how we want to go and see if we can maybe just quick outline that agenda for the next go round.
Well, Mr. Chair, go ahead. That's fine.
Commissioner Vicente Aguilar.
Mr. Chairman, Mr. O'Donnell, is it Arthur O'Donnell?
Correct.
There was previous workshops the last 2 years, and I know that you all had pizza parties. What have you accomplished the last 2 years with Arthur O'Donnell?
Arthur has only been on board since December 1. And I think you will see from those 2 months of involvement in what has happened in terms of the grid modernization proposals that the legislature required, that his input has been a terrific help to that whole process and really created a very good looking umbrella. And we'll see that when he presents at the workshop. Secondly, I think you'll find that he's already engaged very significantly in work on a rulemaking for interconnection, which badly needs updating. And he's brought technical and policy expertise that I believe Commissioner Hall will tell you has been extremely helpful and productive in focusing things and moving them along. So Commissioner Hall, I'll let you follow up on on that as soon as you've chewed your snack there.
I'm
And
done.
please don't talk with your mouth open.
I finished.
Okay, thanks.
But thank you for indulging me. Actually, Arthur's been involved in the interconnection rulemaking with us, and also in preparation for commencing a NOPR procurement rules. And his experience, I think, was probably largely from the California PUC, has been invaluable in helping us create the framework that we want to work within, and bringing to bear concepts and operations that have been conducted by the California, which is pretty, well, I don't know how to describe it exactly, but yeah, as we all know, it's a much larger state with many more challenges, or a larger scope of challenges that we have, larger size of challenges. And so his experience has been very helpful. And so I think he has great insights in those areas, and in particularly in incorporating new technology into our operations going forward, and our standards that we require. I mean, that's our real challenge in these two rules, particularly is how to address the need to rapidly incorporate and requirements that we impose on utilities that involve new technology that they're not familiar with. And Arthur's seen it already in California, and is familiar with sources of information we can go to that will help us integrate the right kind of requirements into these rules. So I'm really glad we have him on staff. It's very, very helpful.
And I will add that one thing that Arthur has already done is help expand our resource base. There's an outfit called GridWorks that has had experience with several commissions around the country, including Colorado, in putting together interconnection rules that catch up with all the modern technologies. And they are in the process of getting a grant so they can help us finalize, develop and finalize this important rule for free. And they're very experienced, and they've seen these rules, and they've helped develop these rules in Colorado, California, where else? A number of states, just within the past couple of years. And again, it's just a tremendous resource where we can lean on their experience. They've learned the lessons, they know the mistakes that have been made, and I think really help us do a better job and leverage our assets to get stuff done.
Yeah. And Mr. Chair, I would just add, that's just one of the many resources he's familiar with. And it really does enhance our ability to not only learn more stuff and incorporate it into our operations as we need, but also to, I forget what I was going to say. There was another value, but I forgot what it was. But in any case, it's very helpful. It's
Well,
very
and I just want to emphasize that, you know, these services get provided under the umbrella of Commissioner Byrd's favorite F word, free.
right.
Absolutely free. So that's just a terrific, it's just a terrific resource that he's enabled us to get funding for, and really help us do some work at a much higher level of detail, attention, and quality than we might be able to do otherwise. So,
Correct.
Mr. Chairman?
Yes, Commissioner Vicente Aguilar.
Can you repeat the date when he started working with the PRC organization?
So he started as a fellow with me as his mentor December 1st of last year.
2020?
2020.
I understand that there were workshops done in the year of 2019. We didn't get a report. Can you tell me what occurred in 2019?
I am not sure which workshops you might be referring to.
The grid works.
I know that go ahead.
It was publicized, the workshops. It's in our email. I'm sure our IT can track it. I would like to know what was accomplished in 2019 involving Arthur O'Donnell with Sandia Lab.
All I can say is I was not working with Arthur at that point. And I know Arthur, works in the energy field and energy consulting field. And I am not aware of specific projects he may have done with Sandia or anyone else prior to the time that he hooked up with us on December 1st. So that might be something that we best direct directly to Arthur. And so I can, basically shoot him an email and ask him to describe what work he may have done with Sandia during 2019.
Yeah, Mr. Chair. Oh,
Yes,
I'm sorry.
Commissioner Hall.
I would just say, I think it was a fortunate thing that we were able to get additional help in our agency during this time when we're not able, we're being thwarted every time we asked for sufficient funding for staff. And I think to the extent we can take advantage of opportunities that exist to bolster our knowledge and our grasp of the issues that we face, especially in trying to create this underpinning for the Energy Transition Act that is our job for the next 2 years. In my perspective, that's one big thing. That's our big job in front of us. There are many other smaller ones, but that's the overarching one in my view that generates the most work for us. So I just think it's fortunate that we can get someone who can be funded by somebody else that's not a regulated utility. In this case, I think he's funded by DOE, if I'm pretty sure that's correct. And to the extent we can get more help to advise the commission during this time, I think that's all for the good. I've been reaching out to Sandia Labs and New Mexico State to see if we can get interns from the university or some sort of consulting arrangement or direct advising arrangement with Sandia Labs just to find out what's out there, because those institutions state that part of their mission is to try to assist government. So I think that we're on the right track finding people like Arthur, because we need the help. I think it's clear from our meeting last week, if it was only a week ago, seems like a long time ago, that as John Reynolds put it, we need more know-how. That was right at the top of his list. They need more people and more know-how. And I think that just sums up the situation, maybe not only just for the utility division, but certainly for me. I can't speak for all the other commissioners, but certainly, we need more expertise. We need more advice based on expertise that this agency lacks, both, you know, in terms of advising the committee and our staff. So I think a very productive route for us can be right now is to try to find as many free sources of expertise that are available and tap them so we can be as effective as we possibly can. So I'm glad that you took the initiative to find Arthur, and I think we need to continue in those initiatives to the extent we have time to do so.
Now I understand, and Commissioner Maestas, that you've also been looking to see if we can get some resources that are essentially government funded, federally funded. Is that correct?
That's right. I think we need more Arthur O'Donnells. And if we can get it complements of the federal government, in this case, through the Department of Energy's Solar Innovators Program, I think that's a plus. And as I've become familiar with the parameters around that program, it's a win-win. It's a win for, you know, whoever becomes a fellow assigned to the PRC based on the benefits and salary as a function of their educational levels. It's also a benefit to us in that we can get outside expertise to help us in the interim. And I think, as Commissioner Hall said, although we're starting to really, you know, pick up the pace in terms of our requests for higher budget resources to get not just additional technical expertise through in-house FTEs, but also have a consulting budget to hire outside experts as, you know, complex cases may require from time to time. So I think leveraging federal resources through this fellows program, I think is going to benefit the agency and benefit us, quite frankly. Yeah, I support this, and I want to see us get some more fellows, and Senator Martin Heinrich's office is already committed to assisting us. So our discussions with his office are quite advanced. We're almost on the brink of recruiting applicants that could be assigned to the PRC under this fellowship program under the Department of Energy's Solar Innovators Program. So can we talk?
Go ahead, Commissioner Maestas.
I was just going to suggest that we maybe get back to the topic at hand and how to move forward on this 2-year plan.
Yes. So I put out a suggestion on the table that we don't review all the notes today, but we do that to kind of kick off the next meeting to see what we've got, and then that we go to commissioners and see how we put it all together when we get Arthur's and the commissioners' thoughts about what they want to achieve. So that was my suggestion, but I'm open to, you know, any format that folks feel comfortable with.
Mr. Chair, I like that. I think, you know, devoting a special meeting to focus solely on completing at least the presentation part of this effort to develop a 2-year plan, I think is better than you know, tagging it onto a regular meeting. Number one, and then number two, perhaps Jonas can send out the notes he has so far, and we can circulate that to not just all the commissioners, but to the chief of staff and all the division directors. Because one thing that, you know, Jonas and I noted is that we still, you know, even if we agree on the primary elements and tasks in this 2-year plan, we need to convert it to an actual plan that has assignments and timeframes, at least for initiation and potentially completion, depending on what it is. And so we still have that vital step to get everything that we have in terms of identifying elements of the plan and then converting it to a real plan with accountability with assignments and timeframes for completion. So I'd prefer to have a standalone meeting. I didn't mind having it on Friday. So I'm in favor of that, Mr. Chair, and we can have Jonas to send the notes out so everyone can review
Yeah.
it.
And I know Brian took some notes and he was coordinating with Jonas to be sure they caught everything they wanted to. And by the way, I thought that was a terrifically productive meeting on Friday. Wore me out a bit, but I thought a lot of really good, particularly kind of process ideas that could help out staff in them accomplishing their tasks. It was very, very useful for me at any rate. Any other commissioner comments?
Mr. Chairman,
Yes, Commissioner Vicente Aguilar.
I see this as very broad. What is our 2-year plan? And when it was first brought up, my first reaction was bringing an innovative speaker for our employees to let them know that they are appreciated. That's what I envisioned when you brought up the subject of a 2-year plan. It was very broad. And what I'm seeing today is we don't have a direct plan to go by. Somewhere along the line, the commissioner said we're going to bring fellows in, which I don't oppose that, but I'm asking for a clear direction. And the reason that I brought up our employees is because, like I indicated in the last meeting, we received complaints that their plate is completely full. They cannot take on any more tasks than what they are trying to get on the agenda week by week so that we can coordinate the case management. So I am seeking a plan that's unclear to me. I jumped in to say, yes, it's a great idea. Let's pay attention to our employees and bring in a professional speaker, because I believe we have that budget available in our training program for the organization. So I need clear direction. The commissioners stated in the previous request, what are your priorities? The action plan is not bold for me to understand exactly what you need. And that's why I said I would like to protect my employees, our employees. It seems like we're shoving additional tasks in their direction, and I like to balance that.
So
thank you, Mr.
Commissioner, yeah, thank you for your thoughts. So I think I'll make a couple comments and let others follow up. I think that Commissioner Maestas summed it up pretty well when he said, gee, what we'd like to see is some goals and then a basic work plan where folks take accountability for getting us to those goals. And also that work plan lays out who's doing what and make sure that we're not overloading folks, that the work plan is something that's reasonable and distributes the work in a way that makes sense. In terms of the fellows, I think from what we saw from last week, and I'll just, from opinion, our staff is loaded down to the gills already with more than they can do. And that the best thing we can do there is prioritize. And I think a lot of what's going to happen as we talk about the work plan, or at least it seems to me, and we'll find out, is that it will maybe help define tasks for each of the commissioners, for each of their assistants, and for all of those additional resources that we hope to bring in, the Arthurs, the GridWorks, hopefully another DOE fellow, perhaps a Sandia fellow. If we bring those folks in, we're creating kind of a new set of resources that can help take on these tasks rather than throwing more stuff on top of an already overloaded staff. And I think that'll be a big part of the discussion. And, all I can do is until we have that discussion, I can't say exactly what the outcome will be. I can say that the goals of commissioners, at least Commissioner Maestas, myself, and Commissioner Hall, have in the packet, our first cut at what the goals might be. And there are a lot more goals than we're ever going to be able to put on in the work plan, but they're just a starting point to whittle down from to decide what we can actually do and what we can't get to. And that's the whole point of going through this process, is to decide what we can achieve, what we can't achieve, cannot achieve, and be sure that we set up a work plan that is achievable by staff without making them work 24/7. And that's the whole point of the exercise. And we can't know the outcome before we go through the process. But, the basic description of the outcome, a work plan with assigned tasks, goals, and a process to get to them, is what should come out the back end. Any other, so that's my thought on it, and other commissioner comments that might help clarify, or at least put your visions forward for what this will achieve.
Well, Mr. Chair, I think you summed it up pretty well. We have to basically identify and prioritize the work that we need to do, funnel off from staff whatever we can, and add value from whatever other sources we can acquire, especially free sources, and try to achieve as much as we can get done under that kind of structure within 2 years, less than 2 years now. So that's what I think we're doing anyhow. That's it.
Mr. Chair, this is Jeff.
I was waiting for you, Commissioner Byrd.
Well, as far as free being my favorite word, it's never free. It's who's paying for it.
True. It's the feds.
Excuse me. Anyway, I have heard the same complaints that Commissioner Vicente Aguilar has mentioned, that the staff is really busy, concerned about how much more workload this could entail. I've been pretty quiet. I listened to about half the meeting on Friday. I was in and out because of doctor's appointments. I was just listening. I was able to hear Mike and Brad and Jim and parts of John. Who else did I? Oh, a little bit of Jason's presentation. And then I got cut off again when Commissioner Hall was speaking towards the end of the meeting, but I know it went on for about 20 or 30 more minutes. But anyway, so I got to hear at least half of it, I think. And no complaints about what I was hearing. It looks like administratively they're working to make some changes that seemed illogical. I think they all had the same complaint: overworked, understaffed, underpaid.
Yep.
And the evidence seems to fit those complaints. I do believe they're every one of those, but they are not unappreciated, guys. We appreciate it. So anyway, I kind of remain quiet, kind of seeing where it's going. I don't disagree with the overriding principle. It's just, what is the impact going to be? You know, there's always that unfunded mandate. Let's make sure that whatever we do bring out is something that we can afford to do. And so at this point, I'm still, you know, participating, but as an observer.
Okay.
Well, Mr. Chair, can I say one more thing?
Yeah, go ahead, Commissioner Hall.
I have to say, I don't think that we should regard these people like fellows or externs or something coming in and imposing more work on staff. The idea is they're supposed to shoulder some of the work. And I can say that Arthur so far has rolled up his sleeves and, you know, contributed with real work, you know, drafting things and bringing to bear his knowledge and advice. So I'm really grateful we have this warm body in the room who can write, think, and knows stuff and can contribute where otherwise we would have had nobody, and it would have been a lot more work for those of us working so far. So that's the objective. That's my objective. And these are not people who are going to come in and start bossing staff around and giving them more tasks. That's not what they'll be doing.
And I'll just kind of piggyback, is if we're doing this properly, part of the goal of any good work plan is to make sure that the priorities are understood, and that when there's too much work to do and more on people's plates than they can possibly do, it's very clear to them which tasks are most important and which tasks they can delay or temporarily set aside. And a good work plan should be a way to help simplify, focus, and make manageable the workload for staff. And that is the goal of it. It's not to, it's to be sure that everybody has clear tasks that are achievable. And that's the exact opposite of throwing more work on folks or throwing more work on them than they can do. And, you know, I can't emphasize that enough. And I want to emphasize that to staff so that they know as we're proceeding with this, we're thinking about all that. And if anything, we want to just make the workload more manageable, not less manageable. That would defeat the whole point of the work plan.
Mr. Chair?
Yes, go ahead, Commissioner Maestas.
I'm not gonna geek out, but you know, throughout my career as an engineer, you know, continuous process improvement has been, I think, one of the underlying themes of like what I've done in my career, and you know, the whole quality management. But I think this exercise, it's almost a blessing not to have a lot of additional budget resources, because this is our time to look at the status quo and identify opportunities where we can do better with what we have. And I can tell you that I don't really see this as an exercise to add more work. I'm already gravitating to, you know, the issue of looking at how we do things. How can we do things more efficient, more effective? For example, you know, we've already had discussions with Utility Division on ways we can stagger the workload. This is something that was in the 2017 evaluation. I've heard feedback from certain hearing examiners that we possibly should have workshops after the notice of proposed rulemaking instead of before. And so that's the way this is evolving for me. It's looking at how we do things today and how we can do them better instead of piling it on staff. And trust me, Commissioner Vicente Aguilar, I do not want to I don't want to pile on to staff that are already overwhelmed and overextended. So at some point, when we have this plan together, there will be kind of a normalization or a realization that's going to be brought to us from staff to say, look, we can do this and this. This is more mission critical, and this is more discretionary. That gets downgraded as a priority. So we're going to have that exercise, and I'm going to be the first to scrutinize it to make sure that it is constrained by existing resources and that it's not an exercise to overextend and overburden already overworked staff. So that's certainly not my intent. And we will have an opportunity at the end before this thing is all tied up to really give it a reality check. And I think staff are going to have, I would like staff to have first crack at it, to look at this and say, yes, 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 maybe, absolutely not. So I'm happy as a commissioner to let staff give it that reality check before we bless it as our 2-year plan.
Mr. Chairman?
Yes, Commissioner Vicente Aguilar.
Well, we have 126 employees. When there's a new idea that's brought up, people's reactions are very different. And if you put yourself in the shoes of our employees, where is their voice in the process? So that's what I tried to clarify last week and today. We're responding to them. We're answering to them. We're clarifying exactly what the goal is without impacting their duties. So I just want Commissioner Mayestas, Chairperson Fishman, Commissioner Hall, I don't know if you realize you threw a fastball into the agenda and there's reaction time. And I was there to assist the reaction time. So that's what it was all about. And I'm glad that all the 3 commissioners have spoken and said, no, we understand where the employees' value of their work is a priority, and we're going to plan it out so it's achievable. So I'm glad that it's been cleared. That's just my input on it, Mr. Chairman. Thank you.
Okay. So, yeah, for all the employees out there, there's a trust issue here, and we're going to engage you all in the process. As Commissioner Mayestas pointed out, there'll be feedback loops on all of this. So we don't end up charging ahead on stuff that doesn't make any sense. And, I think we'll find that we're very, very aware of workload issues and setting people up to succeed in their jobs. And that's what we're going to really be focusing on. With that, what I'd like to do is make a suggestion, is that we go to, that maybe a week from this Friday, we have a follow-up meeting where we do the presentations by Arthur and the commissioners, and that we have all the division heads participating again. And we talk about those goals, or we talk about those priorities for the commissioners, and bounce it off the process issues that we addressed in the first meeting and see where it takes us. Does that feel acceptable to commissioners? And I would set it up as another 4-hour meeting with an agenda starting out with a review of what we accomplished the last meeting, the key points. Then going to Arthur to kind of get the big umbrella picture of grid modernization, and then go to each of the commissioners and their goals, and then come back to how this all fits into the resources that we've got. Does that feel like a reasonable way to proceed?
Fine with me.
Yes, me too.
Okay, Commissioner Byrd, does that?
Yes, that's fine.
Okay, terrific. And
Mr.
Commissioner,
Chairman,
go ahead.
this is Michael Smith. I just wanted to point out that it actually may conflict with a scheduled workshop that was announced for the interconnection rulemaking.
Ooh, we don't want to do that. So could we set up for, say, a Thursday instead?
Wait a minute. Our workshop is on Thursday, the 18th. So I think Mike must be
Friday would-
mistaken. Friday would be the day to have
Yeah.
our meeting. Yeah.
Okay, I'll have to look. Let me look that up quickly. I thought I had it on my calendar as the 19th. I could be wrong.
You are wrong. It's the 18th.
You're dead wrong, Mike.
And don't forget it.
I'll tell you what she was really thinking. You were dead wrong.
Don't mince words there, Commissioner Hall. Just, let your hair down. Just tell him.
By golly, if I'm ever right, I want people to know.
So Michael, you're checking?
Yeah, it takes me a moment to log into our system.
Mr. Chairman, Michael, I can confirm the workshop is scheduled for Thursday, the 18th. That's for case number 20-00171-UT.
Right. Okay, great. I'm making a change on my calendar.
A lot of the time you are right, Mike, by the way.
Yeah. But Michael,
Most of the
never try and sabotage your rulemaking like that again.
He's part of the team.
I was just trying to free
I'll
up my
pay you
Friday.
later, Mike.
So if the commission's comfortable with that, we will have that meeting scheduled for Friday. I'll send out just a preliminary straw man agenda that everyone can feel free to mark up. And I'd propose that we do that the same way we did the last one, 9 to 1, 4 hours, I think is about as much as people can strategize without just getting punch drunk.
Yeah.
So if all are amenable to that, we'll follow up in getting that scheduled.
Oh, wait, are we talking? Oh, fine. We're talking the 19th, right?
A week from this Friday, so that would be the 19th.
Yeah. Okay, that's fine. Yeah.
Okay. Discussion and potential action regarding legislative matters.
Thank you, Mr. Chairman. This is Jason. I just want to touch on a couple of things here. Bills that the PRC is tracking seem to be getting heard and getting due passes for the most part. I know we have a couple of bills, for example, House Bill 51 as amended, the Environmental Database Act, not a huge impact on the PRC. That's made its way down to the House floor. House Bill 245, which has gotten a lot of attention, is the Utility Distribution System Hardening Bill. That has made it down to the House floor. And I have to give the commissioners and others an apology, and I'll try to do a better job at getting the calendar invitations sent out earlier, because there appears to be some committees that require registration 24 hours or at least 3 p.m. the day before the bill is actually going to be heard. And you have to send an email to a specific person that then acknowledges your request in some cases. In other cases, some of the committees aren't requiring a pre-registration per se, and simply publish the Zoom meeting if you want to give public comment. So, Danielle and I are going to try to do a better job at getting that out earlier. And so you'll probably see that we already sent the Senate Conservation Committee schedule for tomorrow. There are some bills. Senate Bill 155, the Energy Transmission Authority changes, is being heard tomorrow. So, and Mr. Chairman and Commissioner Maestas, hopefully you're okay with me announcing this, but we did add a couple of bills to being tracked. That is Senate Bill 113, the wiring for photovoltaic systems. So I'm hoping I'm pronouncing that right. And then the same systems in new homes. And Commissioner Maestas, even though they haven't requested any PRC FIRs, I just wanted to actually recognize that those are also scheduled for hearing tomorrow. We're close to having all of the FIRs completed. I know we have a couple of them that are out there. In particularly, I know House Bill 206, the Utility Affordability and Relief Act. And speaking with John, I expect we will have something published for commission review later today. And I believe that one's scheduled to be heard before committee Saturday. And if I'm not mistaken, a couple of commissioners may have been contacted by the media regarding this piece of legislation. So I'll put a high asterisk on it, bring it to your attention now, that I hope to email that out for your review later this afternoon. The cramming and slamming bill was on the agenda late.
Excuse me, Jason, what legislation were you referring to there?
Mr. Chairman, Commissioner Hall, that is House Bill 206, Utility Affordability and Relief Act.
Okay.
It's a pretty lengthy bill. And just so you know, I have raised my concerns with both LFC and DFA about the 24-hour turnaround time on some of this legislation, especially when, a lot of it is complicated. A lot of them seem to conflict with one another on the House side or the Senate side, or with existing statutes in themselves. And, it's just extremely difficult for us to get 7 FIR requests in one day and have them turned around in 24 hours. It's just unrealistic with our staffing levels and resources. So they understand that, they recognize it. And in the event we can't publish a good quality FIR, in lieu of a deadline, I think that's our best approach. I don't want to put anything out there less of our best effort, right? So that's what we've been trying to focus on. I think we've been able to at least meet some of the extended deadlines that the LFC has asked for. Like I said, I think House Bill 206 is one that they are actually awaiting to make sure that the analysts implements and takes the PRC's FIR into consideration before publishing something for committee's consideration. If I can get that to them midday tomorrow, that gives them more than 24 hours to review it and put something together. So that's my goal. That's what you'll see in the email. With that, Mr. Chairman, Commissioners, I guess I'll just kind of ask if there's any particular bill that you'd like to visit, discuss, get input, feedback, status updates on at this time.
Mr. Chairman?
Yes, Commissioner Vicente Aguilar.
Mr. Chair, I think it's time. We're approaching February, the second week in February, the end of the second week in February. We should consider endorsing certain bills. I think the commissioners should bring forth bills that we feel that should be endorsed by a majority, so that to make our staff members, their job a little bit easier, because right now they're only tracking and monitoring. They can't speak to a certain bill because they're not allowed. So if you feel strongly that we should support one another to stand behind a certain bill, we should start thinking about that right now. Thank you, Mr. Chair.
Okay. Well, so following up on that, are there any bills that commissioners feel that we should be endorsing
Mr.
on this
Chair?
list?
I think before we discuss any particular bills, I think that maybe we ought to discuss which bills should be of interest to the commission. I know that after reading many FIRs, that staff have identified certain bills that to staff represent unfunded mandates that present additional burdens on us. And obviously past pieces of legislation that did require additional FTEs did not result in budget for those FTEs. And so I think we ought to be concerned as a matter of priority of those bills that represent unfunded mandates. And I think we ought to take a position, maybe even identify courses of action for those bills that represent unfunded mandates. The other is preemption of PRC authority. I think that, we need to be aware, and there are some bills that do preempt PRC authority. I think that should be a characteristic of a piece of legislation that would warrant the attention and possibly discussion and action by the commission. And then the third category that I see is just general needs that we know our state is experiencing, especially during this pandemic. And I'm not saying let's go outside of the realm of PRC business, but broadband comes to mind. We know that our state ranks extremely low in broadband. We are a player, not a major player, but I think I would say we're a significant player in the funding of broadband projects. And any piece of legislation that would create a institutional or state agency focal point, would designate additional state funding, would precipitate the development of a statewide plan, should warrant our support. I mean, so I agree with Commissioner Vicente Aguilar that certainly those broadband bills should be supported by us. Now, I think there is still some broadband bills that perhaps undercut our authority, and we can qualify our support of those pieces of legislation. So I just think that we should think about the characteristics of the legislation before we actually decide that we need to discuss them and take action on them. And those are my three, general categories that come to mind that could warrant, some commission discussion and action.
Okay.
Mr. Chair, I agree. I think that makes a lot of sense. Those are three areas that I think are extremely important. And the thing that always bothers me is unfunded mandates, especially since the Energy Transition Act and our present circumstance where we're not funded enough to be able to really implement it without casting about for free labor from outside. So I totally agree with that. I agree with the other priorities Commissioner Maestas mentioned, and I think it's a good idea. I noticed that Commissioner Vicente Aguilar said a majority of the commission. I'm more comfortable with a unanimity. I think if we stick to these three subjects or categories of priorities, I think we probably would be unanimous. But so I would just throw that part out there too. I prefer it be unanimous. It looks better. Then it's coming truly from the entire commission. So anyhow, that's my preference.
Other thoughts? So
Commissioner, Mr. Chair.
Yeah, go ahead, Commissioner Byrd.
Thank you. Sorry to interrupt you there. Yeah, I agree with Commissioner Maestas. The unfunded mandates, SB 156 is a great example there. It's going to add a lot of duties on our staff that are already have a full workload, and we need to push for amendments to ensure that adequate staff comes along with that kind of bill. You know, for me, I support HB 24, and so as a commission, I would be in support of that. But I understand, you know, like Commissioner Hall said, it needs to be a unanimous decision. But so I think this is a good discussion, and we need to look into these and see what we can support.
So it sounds like something we want to set aside time for on next week's agenda.
Mr. Chairman?
I think so.
Yeah.
Okay. Yes, Commissioner Vicente Aguilar.
I would like to set up 3 meetings, 3 different meetings for the commissioners on a weekly basis. Not 3 meetings. I'm sorry. A legislative meeting on a weekly basis, aside from the open meeting.
Okay.
I'm wondering if it's possible to squeeze in legislative meetings on Tuesday mornings, or is that a time crunch for the general counsel's office? Maybe we can squeeze in the legislative meeting Wednesday afternoon after the open meeting, because we need to do our homework to see which bills are going to be a priority, and we need to take action so that our staff members can be well informed.
Thoughts from other commissioners on that?
I'm not opposed.
Mr. Chair?
Okay, Commissioner Byrd.
I like what she's thinking. What I would propose, let's just go ahead and do it during the regular meeting, but between now and then, each of us need to put up specific bills that we either want to propose or have discussions on, and we get it narrowed down to the specific bills that we're concerned about, and we can all get our homework together and make the discussion short as possible without just going down the list of bills.
Other thoughts?
I guess getting back to my concerns, if we can maybe have staff tag those bills that either represent unfunded mandates and or preemption of PRC authority, I think that would help. And then I would, as a commissioner, look through all of them to see which ones I'd like to support that don't fall under either any of those categories of unfunded mandates or PRC authority preemption.
Okay. So I'm comfortable with, the idea that we all, the one staff identify ones that they've got particular concerns about, that they red flag them for us. I think I agree with the idea that each commissioner should, bring their list of bills. I think the criteria that Commissioner Maestas lay out are a good way to structure it. And as to whether we do a separate meeting or incorporate it into the next week's open meeting, I'm trying to get more of a feel for where the majority of the commission sits on that. Sounds like Commissioner Vicente Aguilar wants a separate meeting. Commissioner Byrd would like to incorporate the legislative discussion into our Wednesday meeting. How do other commissioners feel about that?
Mr. Chair.
Yes, Commissioner Hall.
So I think we should do it on Wednesday. I think if our agenda is long, we should take a lunch break and then meet after that. But if the agenda is, if we finish by, 10:45 or maybe 11, maybe we could get it done, go through them by, 12 or 12:30, then maybe we wouldn't all run out of blood sugar. But, I think we need to be, I just think we need a break for lunch, really. And then I'd be willing to do it right afterwards.
Commissioner Maestas?
Yeah, I'm fine either way, whether we have a standalone meeting or do it in conjunction with the regular meeting. But I think, the time has probably come to identify those FIRs from staff that actually recommended amendments and discuss amendments, at this meeting. And so maybe the ball is in our court, as Commissioner Vicente Aguilar, is urging us to do. And so I myself, I'll take it upon myself to screen some of these FIRs and identify where staff recommended amendments and see if we can't even propose some amendments if we take action on that particular bill.
Okay.
Mr. Chair, could I amend what I said? I forgot to raise, Commissioner Vicente Aguilar also mentioned a Tuesday morning. I could do other mornings as well. That Tuesday morning's not a problem for me. But if it's a problem for others, then obviously that won't work. But I don't know, Monday morning, Tuesday morning are okay. Friday morning.
Personally, I'm on board with Commissioner Byrd and hoping it can be a short discussion.
Yeah,
But looking at the number of bills and the things to consider, I wouldn't plan on it being a short discussion. So my suggestion would be we either set aside all day Wednesday if the discussion takes a while and we want to do it as part of that meeting, or we could schedule this for Tuesday morning. And I'm comfortable either way, but my first suggestion would be maybe we should just schedule all day Wednesday. We can just all clear the calendar for then. If we need to take a nice break for lunch, 90-minute break, do that, and just be sure we give it full consideration as part of the normal open meeting. One of the advantages to the normal open meeting is that's where people are used to tuning in, and for transparency purposes, I think maybe that's better serves the public. So I would vote for, hey, let's just set aside all day Wednesday if we need it. Hopefully, Commissioner Byrd, we all do a great job and we can just run through it pretty quickly. But I wouldn't plan on that. So is everyone on board with that?
I like it.
Okay.
I have, Mr. Chair, I have a question for Commissioner Maestas.
Sure.
I thought you listed 3 items. I thought you listed unfunded mandates and the commissioner authority preemption, and there was a 3rd category. What was that?
I think just, bills that are going to move our state forward in areas that we regulate, like broadband.
Yes. Yes, that's right. The bigger issue things. Yeah.
So by the way, on broadband, I had my assistant Brian putting together some summaries on the bills and trying to give me some perspectives from his experience working broadband in the AG's office. And so just to let you know, I'll be having him pull that together for me and bring in those perspectives. So,
Mr. Chair, and just as a general rule, I think that it's not always, true, but most bills that get 3 committee referrals are going to have a difficult time. And there are several bills that fall squarely on the PRC that have 3 committee referrals. So I would hate that maybe if a particular commissioner wants to discuss a particular bill that has 3 committee referrals, that we maybe at least consider that in the back of our minds and maybe focus more on the ones that are getting due passes and have less than 3 committee referrals. in that we spend our time and resources on bills that have a higher potential of passing than those that could be doomed from the get-go.
Absolutely. Okay.
One more question, I'm sorry.
Sure.
I just wanted to ask Jason, what was the bill that he said has made it to the House floor?
Mr. Chairman, Commissioner Hall, there's been two bills that have made it down to the House floor. That includes House Bill 51 and House Bill 245, which are scheduled, the House is scheduled to take the floor tomorrow morning at 9. Obviously, as the commissioners are already aware, when it's on the floor session, there's no opportunity for public comment, so I won't be calendaring those sessions, if that's okay. One other thought, just for the commission's consideration, is when staff flag any bills that have an unfunded mandate, preempt the PRC's authority, or have suggested amendments or brought some attention to some significant issues. If it's strictly an unfunded mandate, I think we would still probably need the commission to take a position, because the way we are currently required to register to speak before the committee is to either take opposition or support. And so just throwing that out there for the commission to remember when we have this lengthy discussion next week. I guess we could also raise our hand and just not speak in opposition or favor of a bill and just bring to the committee's attention that there are unfunded mandates. I could try and attempt that, but for the most part, the way it's been working is they've asked people to raise their hand or register with their position as called upon. So just wanted to share that.
Before we leave this, SB 155, it says Energy Transmission Authority changes. I think it's supposed to be energy ETA amendments.
Yes, Mr. Chairman and commissioners, I probably should have pointed that out. There's a couple of different, when we got the original FIR request, it referred to Senate Bill 155 as the Energy Transmission Authority changes.
Mm-hmm.
Go to the legislation on their website now, and I'll just pull it up. For example, I believe it reads something different, right? So that's the reason for the number there. I mean,
okay.
The header. So the actual title on the legislature's website is Energy Transition Act Changes. So I think we should make that change. It probably brings a little bit more attention to it when you refer to the ETA.
Yeah. Now, that happens to be one of those 3 committee referral bills, but it also happens to be the one that restores authority to the commission in terms of prudence review on plant closures. And this is one that contains the provision we had in our policy goals that we all agreed to. I've been asked to be the expert witness on that in committee tomorrow, just to let everybody know. So I will be there and pointing out that, gee, we really, we had as a commission voted to restore the authority for prudence review on those plant closings. And Commissioner Hall, I want to check in with you particularly on that, because I know you've talked to me and been going a little bit back and forth, and I want to know whether I can represent the whole commission on that or whether I should just be representing myself.
Oh, no, I think you can represent the whole commission. My only concern was that making changes in the bill would affect would create some regulatory uncertainty that might make the bonds less attractive and thereby maybe compromise their AAA rating. But I don't think that's true. Actually, I think the fact that they're securitized by ratepayers really makes them, I think that's the feature that makes those bonds worth as much as they will be on Wall Street. So I do believe we need to have authority to review prudence in abandonment proceedings.
And you're
it's pretty
exactly
basic.
right. These bonds are not on the utility balance sheet. They're not.
Correct.
Yeah. So,
Mr. Chair,
yes.
you know, and I appreciate the courtesy that you extended to me prior to my being seated as a commissioner to weigh in on the list of policy priorities, and that particular one, you know, amending the ETA to restore the prudency review on these abandonment cases by the PRC was already in there. And as a candidate that spent a year and a half on the campaign trail, the fight over the applicability of the ETA was quite exhausting, and I wasn't even on the commission. I listened in on the Supreme Court proceedings and followed all of that. And I just, you know, in seeing the reaction to this effort, you know, to revisit the ETA, that particular aspect of it, I think, has been quite divisive among the Enviro community, the progressive community, and even when Senate Majority Leader Wirth, when we had a conversation with him before the session started, he said it was really fracturing his caucus. And so I would suggest that you speak as an expert and for yourself instead of the entire commission, because I've become very uncomfortable with the reaction from this. I do fundamentally agree that we should retain our authority to scrutinize these imprudent costs. And I think 16276, I think, was a very stark reminder of the need for that authority. But in light of the closure, the proceedings that are behind us on San Juan Generating Station, the fact that the application to abandon the financial interests of Four Corners has already been filed. And I think we all know that the ETA was probably written for those two particular coal plants.
Oh, definitely.
What other coal plant abandonment can happen now that San Juan Generating Station has already been adjudicated and settled, and now we're facing you know, the application to abandon interests in Four Corners. So what would that gain the Public Regulation Commission to have that part of the ETA overturned now? Number one. And then number two, I'm working with the Chief of Staff and all of you, of course, to really make a strong case to get a real proper budget to meet all of our budget needs. And, you know, we're talking, you know, more than $2 million. And I would hope that our position on these ETA changes do not affect our ability to convince legislators that we have budget needs that are much more pressing beyond taking a position on amending the ETA. So I think we need to, there are trade-offs here, and I don't want to create an acrimonious environment over this, when in fact, even if we do achieve this change and get the restoration of our prudence review, what will it gain for us going forward in the context of the ETA? So if I had my way to revisit those policy lists, I would probably vote to remove amending the ETA to restore our prudence reviews.
So real quickly, first of all, I'm perfectly comfortable just being the expert witness representing myself. There's lots of dispute about the prudence review language, but there's lots of attorneys who are interpreting that to say it excludes prudence review on any future plant closing, not just the coal plants. And that's why That's why I, in particular, am taking the position, hey, we should change this. And actually, in working with the sponsors, have basically told them, listen, the ETA has enabled us to do some great stuff. We love the ETA, but taking away prudence review could be very costly to ratepayers. And this language, many people interpret as taking away prudence review on all future plant closings that are done to meet ETA requirements. And Michael, you might just give a quick comment on that, just to give your thoughts, Michael Smith, and then we can just move on and worry about that.
Commissioner Fishman,
we cover this.
could I please make a comment before Mike begins his analysis? Sure. I think that's a good question, and it seems to me, well, the issue you raised about how it may apply to prudence review of other gas plants, the remaining plants other than the coal plants. I agree with Commissioner Maestas that with respect to the coal plants, it's they're already in process, so it wouldn't apply anyhow. It wouldn't be worth that fight. But to the extent it may apply to gas plants, I think it wouldn't hurt to make a friendly amendment, a minor friendly amendment, so that clarify what is that referring to. That's what I think would be a good solution. I don't know if that's what you're going to propose to the committee, but to me that would help. It would only require 1 or 2 words in that one section. I think it's, I don't know what it is, 62.16.6b or something. I think is that location of that controversial language. But I don't know if the if it's too late. But
I'm sorry, go ahead.
Well, if it's in committee, I don't think it's too late to make an amendment. But I'm sure you know the procedure better than I do. But in any case, that's what I would suggest.
Yeah, and the bill is very narrow, by the way. Basically, just covers that, and changes the 10-day securitization approval requirement to 30 days.
Yeah,
which
is reasonable.
Yes, because 10 was not reasonable. But I believe that's the only substantive changes that are in that bill when I last read it.
Yeah.
And I'm going to read it again tonight because bills tend to change. And I want to be sure I know what I'm speaking towards.
Mr. Chair, before Mike comments, I'm becoming a little annoyed because I have heard from other folks in the legal community. They question the applicability. They think that we have more authority in the current ETA than we realize. I've heard from other folks that say that it doesn't just apply to coal plants, even though the air quality standards that were amended seem to apply to existing coal plants that would be in violation to the revised air quality standards. And I just think it's time that we get a legal opinion on that. I don't know, or maybe you all did, but this is frustrating me in that I want to know, based on maybe our own general counsel, what we have, what is the authority, the legal authority and the applicability of the current ETA. That would help me immensely.
Yeah, that's why I was asking Mike to comment on his opinion. And, quite frankly, and I think Mike will say this as well, with the existing language, people will take both sides of the issue. It'll be up to us to decide. And then after we decide, it will certainly go to the Supreme Court. And so ultimately will end up being their decision about how this language works, unless we clarify it ahead of time. Through legislation. So anyway, Mike, go ahead and comment if you please.
So I wasn't prepared with a legal analysis for this today. This is kind of coming out of left field, but I think Commissioner Hall refers correctly to the right section, which is 62.16.6C. And my interpretation of that has been, and obviously, this is not meant to be something that's binding on, obviously, on the parties who appear in front of us. And that's why I always hesitate to issue, proclamations of this is what the law is, because that is usually an issue that's litigated in cases. And the Energy Transition Act and the Renewable Energy Act amendments are far from clear, and are far from tested in applications before the commission. But the language in subsection C is that if a public utility has been granted a certificate of public convenience and necessity prior to January 1st, 2015, to construct or operate an electric generation facility, and the investment in that facility has been allowed recovery as part of the utility's rate base, the commissioner may require the facility to discontinue serving customers within New Mexico if the replacement has less or zero carbon dioxide emissions into the atmosphere, provided that no order of the commission shall disallow recovery of any undepreciated investments or decommissioning costs associated with the facility. So it does, that section appears to handcuff the commission's ability to essentially analyze and disallow recovery of undepreciated investments based on prudence, since that would be the most common basis of prudence, reasonableness of the expenses, because those would be expenses that are currently in rate base. I see this as extending beyond the coal plants, which are the qualifying facilities that you were referring to, Commissioner Fishman, because there will be, as the Energy Transition Act pushes utilities to meet the air quality standards, or the carbon
Emission standards.
At those benchmark dates, they will have facilities that will likely be necessitated to be shut down ahead of the expiration of their normal depreciation schedule and useful life. Will be undepreciated investment involved in that. So I believe that's what this is referring to, is not just coal plants, but to the other generating facilities that are currently make up the generating resource base for the utilities that will be shut down. So
I'm just going to say it is completely frustrating. I agree with Commissioner Maestas on that, but we'll never know until somebody takes it to the Supreme Court. And the real issue is, for me, if it's not an issue that it applies to any of these other plants, then folks should not have any problem with changing the language to make that clear, which is all that 155 does. If that's their intent. But otherwise, I don't know why you would leave the language unclear and risk stripping away our authority. So to me, and again, speaking for myself, which is how I'll do it at the hearing, for me, if in fact you don't think the current law is going to create a problem with our authority, you still shouldn't have any trouble changing the language, because it's just clarifying what you're already saying you think it means, rather than leaving it up to the lawyers. So anyway, just one man's opinion.
Mr. Chair, this is Jeff.
Yeah, Commissioner Byrd.
Just a quick thought. But I think the ETA only applies to coal plants because it talks about qualifying generating plants, and it then defines that as coal-fired plants.
Again, you'll find lawyers on all sides of the issue. So
yeah, we got to quit listening to lawyers. They don't know anything.
Yeah, unfortunately, they're the ones who take it to court, and then the court makes the decision for
Right. They're always looking for a reason for existence, but they don't know what they're doing.
them. That's what I'm afraid of.
But I think that needs to be pointed out. But I agree with what you're thinking.
So anyway, that's where I'm coming from, and you know, I don't ask any other commissioner to agree with me, but at least there's my point of view out there on the table.
Mr. Chair, what's the committee? What's the committee meeting that you're?
Double check which committee it is. I think it might be conservation.
Yes, Mr. Chairman, Commissioners, tomorrow's meeting is before the Senate Conservation Committee. And yes, Commissioner Messes is correct. This bill is assigned to 3 committees. I believe after Senate Conservation, upon a due pass, it would go over to the Senate Tax, Business, and Transportation, and then Senate Finance Committee, then Senate floor, then over to the House for concurrence. So it has a pretty lengthy process ahead of it.
Yep.
Okay, thank you.
So clearly leadership is not behind this, to be clear.
Perhaps the governor may not sign that even if it does get through those hurdles.
It's possible, that's very likely true.
Yeah.
But Mr. Chair, just to end this discussion, and this is something that I can, we can continue, but I think that it warrants discussion at some point. I had a lengthy discussion with Mike about the ETA trigger. And to me, I thought it was a number of criteria that's required. It's the emissions issue. Is it in violation of the air quality standards? Number 1. Number 2, is it rated over? I think the threshold was 300 megawatts. But my point is, I thought that there's a number of criteria that comprises the ETA trigger and application. And at some point, I want to be clear, and maybe I must be clearly in the minority in understanding when the ETA is triggered. And also economic impact mitigation. Economic impact mitigation part of ETA really implies closure, not abandonment of financial interest. So these are just the issues that I'm thinking about, but I would think that it's our call to go through all this checklist within the context of the ETA and then determine, okay, this plant falls under the ETA. And then we move on and process it under the ETA.
Chairman, Commissioners, I don't want to. I'm not going to try and get into a whole thing on the ETA, and I guess part of the problem is sort of everybody's common term use of the ETA. The ETA is a very specific section of what was Senate Bill 489. That bill also affected a number of changes that people are still sort of lumping in as ETA. But the Senate Bill 489 made a number of changes to the Renewable Portfolio Standard and other provisions in the Public Utility Act that operate independently of the provisions in the actual Energy Transition Act in Chapter 62, Article 18, which relate to the closure of coal plants, as Commissioner Byrd was referring. So there are different criteria that apply in terms of the closure of coal plants and what happens, and the changes to the Renewable Portfolio Standard, which drive the future closure of gas generating plants and the Commission's ability to address the undepreciated investments or stranded costs that are implicated in the closure of those plants to meet the Renewable Portfolio Standard. And I think that was the provision that Commissioner Hall was referring to that I was addressing.
Yeah, it was in the Renewable Energy Act. It's not in the Renewable Portfolio Standard section of the Act, but it's in the Renewable
It's driven
Energy.
by that.
What?
It's driven, those closures would be driven by the need to meet the Renewable Portfolio Standard.
Correct. Oh, yes, certainly. I would think so.
Yes.
So, I mean, it was a reasonable place to put those provisions, I think, in the Renewable Energy Act. But you're correct, it's not the Energy Transition Act. That's 6218, and Renewable Energy Act is 6216.
Well, let's defer this discussion to Wednesday of next week when we're going to get into more depth. But I'll still be the expert witness on this, representing myself, and because there is some uncertainty on the commission, and I think that's the way to do this properly. And
I think that's fine.
Yeah, then we'll go from there.
Yeah.
Okay. Next up on the agenda. Communications with the chief.
Thank you, Mr. Chairman and Commissioners. I meant to refer to a couple of dates in the previous agenda item, just real quick. The last day to file any legislation is February 18th. And so obviously staff and I have a big heart on that calendar date. So that's when a lot of the FIR requests should slow down, with the exception of any potential amendments. We'll still have to respond to those. And then the session is scheduled to end on March 20th. And we also have a big heart around that date as well. Just a couple of items I'd like to revisit real quick. The PERA building, not any PRC employee, but the PERA building has other agencies that are housed within there, and they had an exposure, a COVID-19 exposure, hence the reason for the email yesterday. And so they're disinfecting the building today. I think the person may have accessed a PERA building last Thursday. So very minimal exposure to the PRC staff, obviously, but we have asked them to refrain from accessing the building. So if anybody has any mail to pick up or any checks to deposit, please coordinate that directly with Gabe Cassell from the Administrative Services Division. You should be getting a draft lease via email. We are targeting an April 2021 move-in timeframe to the Vulcan building. I have been in contact with the Board of Finance, and the last item they need in order to transfer the money per the Board of Finance grant application approval is the lease. So I will probably be asking for a pretty quick review and turnaround on comments. It has gone through, it will also go through, legal review. But I did start with the General Services Division template that they use when any state agency negotiates a lease with a building that is not owned by the state per se. So I'm using that one as a template, and we've made adjustments and comments. And so again, that's forthcoming. And other than that, everybody seems to be doing fine, busy as ever, as you've already alluded to and recognized, and appreciate it. Appreciate all the comments on behalf of staff. I'm sure it's warming to hear from commissioners and your and just recognizing their participation, commitment to the success of the PRC. So I wanted to thank each commissioner for the positive comments and communication to staff that are actually participating via YouTube or are actually participating via the Zoom platform. I think that's really all I had. I can stand for questions.
Any commissioner questions? Okay, let's move on to communications with General Counsel.
So, Mr. Chairman, I have a lot I wanted to cover. Just kidding.
Thanks, Mike.
You're welcome.
Are you done yet, Mike?
That's it. I'm done.
Michael, this is Russell.
Oh, Russell has something to say. Don't blame me.
Yeah.
Okay.
Good afternoon, Mr. Chairman, Commissioners. I've been asked by, I and also Mike Ripperger have been asked by the attorney for the Communications Workers of America. That's the union that represents some of the technicians that work for CenturyLink in particular, and I think some other telecom companies as well, possibly. They have they've asked us to meet with them to discuss what the subject line of the email that they sent me was to discuss legislative bills on telecom regulation and broadband deployment. I don't know any more detail than that. As you will recall, the CWA has taken positions with regard to CenturyLink's current legislation regarding a proposed bill regarding the New Mexico Telecommunications Act regarding quality of service, et cetera. So I told them that I would need authorization as counsel for the commission. If the commission wants me to be involved, then I'll need the commission to go ahead and authorize me to do so. I don't have a preference one way or the other. You may recall that I think it was in the spring or yeah, I think it was the spring of last year that CenturyLink asked Mike Ripperger and I to become involved in meetings just concerning their proposed legislation. So, and the commission actually decided not to authorize me to do so. So that's about all the background that I have. So if the commission would like me to do that, then if you give me an indication here today. If you don't, then I will not. And Mike Ripperger may have already met with them just to get an idea of what in particular they wanted to talk about. I don't know if Mike is on this meeting today. If you want more information, but I think you have a good idea of what they're interested in.
Thoughts from the commission?
I have no problem with them talking to them. To the extent our agency can provide information to members of the public or anybody, legislators, I think that's appropriate. And it actually reminds me of an instance where I had a legislator, I guess maybe it was last week, who wanted to speak with Russell, but he didn't feel free to do that without commission approval. And I think I don't, they may have moved past wanting to talk to him anyhow, but I think I would like to know what the commission feels when there are legislators who would like to just get information about how we're conducting our business with respect to broadband. Or I think in that particular instance, they wanted to know what the effect of their proposed bill would be.
Mr. Chairman and Commissioner Hall, if I may, this is Jason. I thank you for bringing that up.
Yeah.
Often we are solicited to answer and respond to questions within our FIR or even to provide input. Personally, I have no problem with responding and at least allowing technical staff to answer questions. Again, refraining from committing the PRC or actually taking a position, even if it's personal position on any piece of legislation. But we struggle with those requests, especially since they tend to happen in between open meetings. And so some direction would be much appreciated from the commission on how to respond to those inquiries. And maybe we allow ourselves as the technical staff to make an educated decision if we are uncomfortable and should refrain until we go before the commission. But, I think if I can at least say, if you all feel comfortable and it's not something that overcommits or even commits the agency at all, I don't know why we wouldn't respond. So I just wanted to add to that.
Mr. Chair, this is Jeff.
Yeah, go ahead, Jeff.
So I'll give a reason why we shouldn't. For consistency, if you guys remember, we denied them talking to CenturyLink on legislative issues. And this is the other side of that story. This is the union that works for CenturyLink. It seems like it would be improper for us to say, yeah, you can talk to one side, but not the other. So I oppose this just because You know, I kind of thought they should have talked to CenturyLink, but we as a group said no. So I think we should say no here too.
Mr. Chair.
Commissioner Maestas.
Yeah, I agree with that. I think the only general circumstances under which our staff should provide information and potential just objective technical assistance or advice is, to another public entity, whether it's legislative council services or a legislator, with the proviso that they not, try and take a position either way, but provide factual, objective information, because I think it would benefit the PRC in that we would be known as housing subject matter experts that can help move the industries forward and help our overall objective of effective, efficient, and equitable regulation of these industries. So I see our staff as vital subject matter experts that should be able to add to the discussion surrounding a process, a regulatory process, a technical area, because I just think we're better for it as a state, we're better for it as an agency. And in fact, this is my own personal opinion, I see legislators consulting with other subject matter experts and moving forward on a certain aspect that perhaps is not ripe for implementation. And then we're saddled with having to implement this issue that perhaps was not really thought through, was not piloted. And so I even see our agency being a test bed, a clearinghouse for a lot of these maybe advanced ideas that a certain legislator has in his staff. And I think to a certain degree, we can play a role in that instead of legislation getting too far ahead and moving forward on a certain area that is really not right for full statewide implementation. So I would limit it to, just objective, informational assistance, but in the public realm, not in the private realm, and certainly getting in between and upsetting a regulated entity unnecessarily may hurt us. And so I agree with, Commissioner Byrd in this circumstance that we probably shouldn't get involved with these private entities.
Mr. Chair, I agree with that perspective. And I really agree with the concept that certainly our lawyers from general counsel and staff as well should be able to just provide information based on our expert knowledge to legislators and other government entities. It can't hurt our profile, I don't think.
So
I don't know. I think we might be overtaken by events now in this one instance.
So Jason, is this input giving you any clear direction?
Well, let me just, if I may, Mr. Chairman, I think I totally agree and understand the request of Russell regarding the existing situation of somebody wanting to have a meeting. But moving forward, I guess, just generally speaking, how do we want to address it to legislators and analysts and others?
Broke up, Jason, I couldn't hear what you said there for a minute. Jason, not Jefferson.
What was the last word? I'm sorry, Commissioner Hall.
I don't know now. It wasn't very long ago, but.
We lost about 20 seconds.
Yeah.
Let me start over. How about that?
Yeah.
So I totally agree and understand the situation in response to what Russell has inquired about, but I'm looking for more direction on the general side of it when legislators or analysts approach the PRC and would like to ask questions about the FIR and or would like to present questions in general about the bill. As you can imagine, I think if we don't get clear direction, it puts us in a very difficult situation of making a decision. And I just would hate for some staff member to make the wrong decision. And then
Maybe limit it to division directors.
I don't need to ask for limiting it to what specific staff. I can manage and control that. It's just, do we respond at all? I think we have a role in the legislation, and am comfortable with responding to legislators and analysts that are working on the bill or working on behalf of a committee, as long as we remain within the constraints of the FIR, since it has been vetted by technical staff, it has been vetted by general counsel or legal, and it has been shared with the commissioners. So everybody's been given an opportunity, and a lot of times the opportunity isn't a lengthy amount of time. I understand that respectfully, but it's been somewhat vetted through legal and OGC. So I would actually ask to be allowed to let technical staff and/or myself respond to analysts and legislators if they were to have questions.
Mr. Chair.
Commissioner Byrd.
Quick question, Chief. Are these questions in reference to the FIRs that are submitted?
Yeah, Mr. Chairman, Commissioner Byrd, for the most part, yes. But as you know, once you get into a conversation, there's potential for other questions to be presented based on responses. And so it could potentially turn into an open discussion of the bill itself. I would hope that most of them are directed towards the FIR. I've received a couple, and it just wanted me to clarify if it was a typo or something very, very minor. Didn't change the FIR, didn't change the content at all. That was more of a transportation FIR that was dealing with where should the motor carrier fees we collect be deposited. I mean, wherever. But anyway, that's just.
Did you tell them PRC general fund?
I did try to tell them that it should remain with the PRC. They didn't want to hear that.
That's all right. Some people are ugly, but we don't mind being told.
But anyway, I think it's a good conversation. I mean, I think we probably need to accept the fact that the people across the street are going to seek advice and input from the PRC.
Mr. Chair.
So, Mr. Chair,
Commissioner Byrd first.
Yes, he can talk.
Yeah, continuing.
So my take is that they need to be responding to questions. Our staff are all professional, and I think for the most part, there's always going to be an oops every now and then, but for the most part, they're going to know to stick to the line of the general position that's in the FIR, and that they should be responding to legislators who are trying to just get a better grasp and understanding of what the issue could be. And so letting them respond, I think, is a good thing. If it comes up that we need to support or oppose something, then that's what we're going to be talking about next week.
We could talk about this next week too, I guess.
Yeah. Well, Commissioner Hall, any thought there? Just because we got a week in between here that.
Yeah, I mean, actually, maybe we should just deal with this issue next week as well. I don't have more to add.
My thought is there's pros and cons, but
yeah,
I'd rather give staff leeway to communicate, and if we see problems come about as a result of that, we can deal with them then. But for right now, I just as soon extend that trust to our staff to handle it professionally, and not presume that it would happen any other way. So frankly, I'm comfortable, Jason, if someone calls and wants clarification of an FIR, that staff should be able to respond directly.
Yes, Mr. Chairman, I appreciate that. And also I would just add that if in the discussion something comes up and we want to flag it, it obviously is an opportunity for me to bring that before the commission with our technical expert during the legislative matters conversation during the next open meeting.
Mr. Chair,
Commissioner Meistus.
with specific regard to Russell's request to address the CWA, the communication workers, the answer is no, correct?
Correct.
Correct.
I think it should be. Yeah.
I think we
But-
all agreed on that. Commissioner
And with-
Vicente Aguilar, did you have any thought on that?
I agree.
Okay, terrific.
Mr. Chair,
Yes.
however, with respect to the request for information from the legislator, the answer should be yes, right?
Yeah, we're saying respond to clarify an FIR. Staff should be able to do that.
Yes.
Yeah.
So Jason, you clear?
Yes, I believe so. Clear as mud.
Okay, I'm glad we were able to solve that for you. Anything else on communications with general counsel?
Yeah, Mike needs to get control of his staff. Good grief, Mike.
Russell's a wild card.
Yeah.
Oh, hey,
Thanks,
I don't
guys.
know what I was doing. I was communications with commissioners, sorry.
Mr. Chairman,
Yes, Commissioner Vicente Aguilar.
earlier in our discussion, I said let's start paying close attention to the bills, the legislative bills. Be prepared to discuss your position on certain bills. Be prepared to vote. The reason that I say that is because I've been listening to certain committee meetings, and they are putting PRC in a very bad position. They're using harsh words to describe us, and I don't think that is right. The word discrimination is being used to label us, and I just want to put that on the table so that everybody can be aware of that. And let's get our job. Let's do our job to start. If we can get unanimous support on certain bills next week. So I would like to ask you, Mr. Chair, is that we do our, like Commissioner Hall said, if it's a short meeting, if we're done by 11, we can go into the legislative bills. But if we're going beyond 12 noon with the regular meeting and getting into legislative bills that afternoon, give us a break for about half an hour to eat, and then we can come back.
No, I'll give you more than a half hour. We'll get a full hour. So people can come to it fresh.
Sounds good.
Yep.
Other communications with commissioners. Thank you, Commissioner Vicente Aguilar.
Mr. Chair,
Yes.
I just wanted to thank General Counsel's office for getting our packet out by Friday. Although there were 2 carryover items from the previous meeting, I still want to recognize OGC that they are striving to achieve that goal of not just getting the agenda out, but all the packet materials. So it is much, much appreciated. Thank you, Mike and the team.
Ditto. It sure makes it a lot easier to just look at a package and know everything's there and not worry about stragglers.
Right. Thank you
And-
very much, Mike and Judy and Russell and Hans. Did I get everybody? And Isaac.
And we hope it ends up saving you work too. I have an item here is I've started floating the idea with a number of people, and I don't think anyone's gonna touch it this session. But we have this, there's been a series of bills that have just kind of and initiatives that come forward the last few years that are sort of add-ons to the Renewable Energy Act, add-on to the Public Utilities Act. And every one of them seems to add a docket that needs to be decided, a separate docket that needs to be decided at the commission. And I think it's created some issues. One of the issues is we have so many dockets that we've created kind of decision silos where maybe we're not looking at the whole picture as well as we could when we're making all these decisions. Second is, a lot of this stuff seems just straight out duplicative. I mean, we've got an IRP, we have a renewable energy docket that's separate from that resourcing planning. And then we have separate dockets for approving non-renewable resources. And it seems to me that as the legislature has tried to push these very worthwhile initiatives, that it's resulted in metastasizing in the number of dockets. And it doesn't serve the public particularly well because there's so many dockets, they don't know where to participate in what or what to follow. It's difficult for interveners. And it quite frankly kind of balkanizes our decision making because we've split all this into so many dockets where things kind of overlap. And I was thinking that it's a good idea to see if we could get some kind of task force together about how we could take all of this and come up with some ideas to streamline it so that we're not making decisions in little decision-making silos, that things are better connected and that there's sort of more of a process to it. And that would involve, task force would involve interveners, utilities, certainly PRC, folks over at NMERD, but just something that would streamline and kind of rationalize this group of dockets that we currently struggle to get through. And but maintain all of the policy initiatives that we have, just streamline the docketing. And so I just wanted to let the commission know that I'm floating that idea to see if we can get any folks who want to participate in that kind of process and see if that can generate some future streamlining legislation. So that's really all I have to say about it, and I'm welcome to hear any thoughts from you now or offline about whether that makes sense to you. But I think it would certainly be a great service to our hearing examiners and probably to us in terms of following all of these different adjudications. So that's that.
Mr. Chair, I think the hearing examiners would be somebody you'd want to hear from. I think it's a great idea to streamline cases to the extent we can, but if there's some sort of legislative, statutory mandate or something that it has to be treated differently, although I've never seen anything like that, then maybe you couldn't get around it. But I think that would be a place to start to get input.
Yeah, I talked to Ashley about it yesterday.
Oh, good.
And he was all for the idea of, coming up with some rationalization. And right now, it's kind of uncertain about what can belong in which docket. There's ambiguities.
Well, I think there's flexibility, actually. Yeah, it might be kind of ambiguous, but sometimes there's flexibility, like we sort of saw today, but not really. I think we all concluded there was one docket to put the prudence issues we were discussing earlier, but I think probably something we'd have to look at on a case-by-case basis in a way. But that's exactly what you don't want to do. Well, I don't know. The hearing examiners would be best positioned to look at that.
It's just the idea of stepping back, getting a group of stakeholders together and seeing if we can kind of rationalize and streamline all these individual dockets and maybe eliminate some of what I've seen confusion when I've participated in some of the hearings about what issue belongs in what docket and why, and
Yeah.
spend more time talking about that than about, the issues theoretically were at hand. And
So, yeah, okay. So you're talking about stakeholders as stakeholders. So that means interveners.
that means interveners, utilities, and agencies that are involved.
Correct.
Okay, so it could be the Attorney General.
Mm-hmm.
So just coming up saying, gee, maybe we could do this a little smarter, create more clarity and reduce workload. And that can be supported with our suggestions at the legislative level,
Mm-hmm.
as well as whatever we devise internally.
Yep. Can't hurt.
Okay, so I just wanted to let folks know that I was floating that idea around and
Yep.
open input.
Sounds fun.
Any other thoughts from commissioners? Terrific meeting. Mike, you were the star, and Jason, you were the co-star. And I didn't say that for any particular reason other than I wanted to leave on a positive note. And with that, we're adjourned.
Appreciate it, Mr. Chair. Take care.
Bye.